What up, everybody? Let me adjust my mic here. 7 a.m. Are you about to go to work or what? So how's the stream looking? Everything looking okay? You guys can hear me right, and everything's all good. Haven't gone to sleep yet. I understand how that is. Yeah, it's only 10 here. Here I will. I gotta post an announcement real quick. Sweet. Okay. Awesome. You guys can hear me. You guys can see me. You guys can see my cat. Birdie, what are you doing? I think that will work. I don't know how far 4 to 6 inches is. But yeah, let's get to it. So this is the plaintiff's reply to strike matters filed. I knew they were going to try to strike something. So to strike matters filed in connection with defendant's motion to dismiss on grounds of form nonconvenience. So defendants based their form nonconvenience motion on a curated and misleading presentation of the facts, including that 1. The pertinent forum selection clause covers all disputes that relate to the arguments. 2. The clause constitutes an agreement bring any claims arising anywhere in Korea. And 3. All relevant conduct occurred exclusively in Korea. Now that Nexon has exposed defendants' misleading premises, defendants attempt a do-over, submitting submitting 4 new declarations on reply, including from 2 previously undisclosed experts. Because defendants could have addressed these matters in their moving papers but chose not to, so that their motion would artificially appear stronger at first glance, they should be stricken. S&W Forest, whatever they cite, a court case. Do they actually quote it? No, they do not. Nexon would suffer prejudice if the court were to allow defendants a mulligan to which Nexon is not permitted to respond fully, including with respect to the following: jurisdiction and soul. What's up? Yo, what did I say? What's up, Mike? Adam? Seth? Phantom? Yo, what up, Phantom? How you doing, Austin? Welcome to the stream. I'm just going to be reading this document out and kind of giving my opinion. Obviously, I don't have a lawyer here present with me, but my either my buddy Matt, well, technically his my his wife, my other buddy, is going to look over this tomorrow, and then maybe my friend Sean. But yeah, I'm gonna read through this, give out some quick opinions. So far Nexon has cited a court case, but hasn't actually quoted them. Andrew C. What up, Andrew? Yeah, so this is a new court document. It just dropped like literally 10, 15 minutes ago, I think. So yeah, they probably just submitted this like literally at, oh, it might say doesn't give a time. But yeah, they probably submitted this at like 4:49 or some stupid shit. Yeah. So Radice, this is the Sir reply. So yeah, this is the Sir reply that Nexon wanted to submit, so that they actually did get to submit it. They submitted it in writing. There was no verbal argument. My assumption was if we didn't see it today, that they probably held some kind of verbal argument. But yeah, it showed up at 10 o'clock at night, which means they probably submitted it at like 5 p.m. And then it had to be verified and all that stuff. So, and then it could take a few hours to get through the processing. So Nexon would suffer prejudice if the court were allowed to allow defendants a mulligan to which Nexon is not permitted to respond fully, including with respects to the following: jurisdiction and sole. In advocating sole form form selection clauses, defendants had the burden of proving they were subject to jurisdiction and sole. Instead, defendants misleadingly characterized the clauses as Korean form selection clauses. And Jean's original declaration was carefully worded to consent to jurisdiction only in Suwon, because defendants could have established they were subject to jurisdiction in Seoul in their moving papers. The court should strike Jean's belated non-objection to suit in Seoul. So that's tit for tat. Okay. Essentially, what they're saying in this paragraph is that the first, without referring to, thanks, Bobby. So what does a strike mean? It means that they want to get rid of that information off of the record. One second. Excuse me. My summer allergies are kicking in. The heat has been rapidly fluctuating and it's messing my allergies up. Something crazy. So what a strike is they want certain information removed. In this paragraph specifically, they want the latest disclosure from, what was his name? Mr. Jean? Yeah, Mr. Jean. They want his newest declaration that says that they are open to having this suit go forward in Seoul. That Iron Mace is open to having this suit go forward in Seoul. So they want that stricken from the court record, essentially. Legacy, I literally just started. This is like the first real paragraph. So here's the start. So yeah, the jurisdiction in Seoul. They want to try to have Mr. Jean's most recent declaration stricken from the court record. That says that they're open to the case moving forward in Seoul, and it doesn't have to be in Suwon. And then they're saying inconsistent positions on Seoul jurisdiction. And advocating Seoul form selection clauses, defendants knew they would need to explain the contradiction with their position in Suwon, in which defendants stated in writing to the Suwon court that Seoul Central District Court was not the competent court with jurisdiction for a claim against Choi for stealing trade secrets, and orally that Seoul has no jurisdiction over the case. So they said this. Iron Mace said this in the Korean court. So Nexon is kind of conflating two issues right here, and you don't see that So if you look closely at this, Nexon is being kind of sneaky. And what's up, Mr. What up, Mister? Yeah. So this is a brand new document. It just dropped. Like literally 10 minutes ago. I'm just a few paragraphs in. The only thing that's really been covered is that Nexon feels like Mr. Jean's latest declaration should be thrown out and stricken from the court. And now they're arguing that Nexon is arguing that that Iron Mace is arguing that Seoul has argued two different stances. That their position is inaccurate or inconsistent, because in Korea they argued that Seoul Central District Court was not the correct court for Iron Mace to sue Nexon. But they're in this request, they're also conflating two separate things, right? So Iron Mace sued Nexon in Korea. It's not the other way around. Iron Mace sued Nexon in Korea, and then Nexon countersued in Suwon. And the reason why Iron Mace sued Nexon in Korea in Suwon is because both Iron Mace and Nexon are both located in Suwon Central District, right? That's their court district. So Nexon is being kind of sneaky here. So it would be easy to say like this would be a zinger for Nexon, because yes, at some point, Iron Mace has argued that Seoul is not the proper district to handle this case. but that was referring to the case of Iron Mace suing Nexon, not the other way around, if that makes sense. So they're conflating two different issues, and they're trying to present it like Iron Mace is saying that. Um, wait, what the heck? Oh, it's trying to like. What is this? Sorry, I don't know if it just went to like add or whatever, but it said it like popped up a button to insert an ad. Oh, that's weird. Yeah, this is my first monetized stream where I monetize live. So if it adds an ad in, just let me know. Um, I don't really have control of. I mean, I clicked a button. Okay, cool. Um, but yeah, so they're trying. Nexon is conflating two different things. And if you notice correctly, if you read this, it doesn't say that they've argued this in the U.S. because they haven't. So in advocating sole form selection clauses, defendants knew they would need to explain the contradiction with their position in Suon. So this is their contradiction with their position in Suon. So they um so can you still hear me? No, you probably can't hear me if there's an ad playing, can you? So but if you look at this sentence right here in the very beginning, I mean it's a long run on. It's basically like the entire paragraph. But right in the beginning it says that this argument was made in Suon, but what they don't say is that that argument was made because Iron Mace was suing Nexon, not the other way around. So, uh, hold on, let me do something real quick. There we go. Um, so yeah, it makes it seem like Iron Mace has had the position that Soul is not the correct venue to serve um, this case, but that's not the argument at all. They made that Iron Mace made that argument against Nexon because they were in the process of suing Nexon, not the other way around. And oh, cool, rad. Um, yeah. So if you guys aren't getting ads, then I'll just keep going. If anybody misses anything or needs me to repeat stuff, I don't have really an issue with it. I don't like cut these streams and post them into videos. Um, I might do that with this one because it's just so short. Um, but I don't know. I usually don't. So, where was I? For a, yeah, was not the competent court with jurisdiction for a claim against Troy for stealing trade secrets. Docket number 41-1. Uh, and orally, that Seoul has no jurisdiction over the case. That's because this was Iron Mace versus Nexon in Korea. So that means that Seoul wouldn't have jurisdiction in that case because this is Iron Mace suing Nexon, not Nexon suing Iron Mace. So Jean's denial of defendants took an inconsistent position and is belated and not credible. He fails to offer any way to reconcile defendants' statements in Suon with his bald denial. Uh, that's kind of unimportant to the case, to be perfectly honest, at least in my opinion. So this whole statement is basically kind of unimportant to the case. So FISEB, basically, this is Nexon's Sir reply to Iron Mace's last reply. So it's like responding in kind. So far, they've argued that they want to have Juan's last declaration. So Iron Mace's Korean lawyer, they want to have his declaration and everything that relates to it stricken from the court records. So their first argument is that uh, it was filed and basically filed it when it shouldn't have been, and that uh, the positions are inconsistent. Yeah, I don't. So far, I mean, I'm only 2 pages in, but so far, none of this looks like it would hold any water. Um, and that's just not like literally. That's not me trying to be biased towards Iron Mace. Like this just doesn't. If you look at the direct wording, so they're trying to take an argument that Iron Mace had it in the Suwon Central District Court when they were suing Nexon, um, and trying to make it apply to the case where Nexon is suing Iron Mace. And that's just not the case. And in the United States, that's not really how things work. So this is just trying to kind of muddy the waters and get by with sneaky language. So scope of the forum, but there might be something in here that is more valid and fact based. And if you look at they cited a court case right here, Cedar Shake and Singleman, and they don't even cite it. Like they don't even quote it. What up, Connor? The documents are looking pretty decent so far. I've only read 2 paragraphs. Um, it's just this reply from Nexon. Right now, there's nothing super substantial. It's stuff that can be kind of easily kind of tossed out. There's nothing really damaging to Nexon or Iron Mace in here. Yeah, it's more of the same stuff as far as I'm seeing. So they're claiming that there's inconsistent positions. They're claiming that the jurisdiction in Seoul is the correct one, but our Iron Mace is arguing against it and trying to get it into Suwon. So they're trying to have what up 60 plus people, FaceAb, Connor, IDK, thanks Benji, Luke, Silent Killer, thanks for showing up, guys. Nobushi, Knit, Brain, you guys are all freaking amazing. Thanks for joining in. Yeah, Silent Killer, Drake. Thanks, guys. You guys are all rad. I love you guys. Let's keep reading. Yeah, so the scope of forum selection clause. Defendant's motion argued the parties intended from the forum selection clause to cover disputes related to the agreements at that term is used in U.S. case law and offered no other possible interpretation of the Korean language phrase. Instead of attempting to support their original argument, defendants advanced a new theory from Professor Lee that the Korean words have a broad scope that covers this dispute, but Lee's 1 paragraph opinion about what the parties intended is inadmissible ipsy dixit. He does not address Professor Suk's analysis that the agreements were directed to Park and Choi's employment, not post-employment torts committed at a company that did not exist during the time of employment. So what they're trying to say is that because Iron Mace didn't exist at the time of employment of Mr. Park and Mr. Choi, Iron Mace themselves couldn't have, or Iron Mace as an entity couldn't have signed that document based on one interpretation of the contract, and they want, so they're trying to get every piece of that reply thrown out, is what it seems like, because they're trying to the language. So Mr. Lee's opinion, they're trying to get his thrown out because he says that it covers a broad scope. What up, Tadpole? What up, P4, PB, and James? All Star. You guys are amazing. Thanks for joining. Birdie, what are you doing? Want some scritches? Good girl. So I'm gonna ask you guys a favor, just so that can somebody post like a TLDR, and I'll like in the comments, and I'll just pin it, or I could pin it. But yeah, this shouldn't be super long. So yeah, well, they're trying to argue that because the language professor that Iron May cited was talking in broad terms, he doesn't dismiss the idea that Iron Mace was not an entity because it wasn't an entity that existed at the time of employment, so technically Iron Mace couldn't have signed that employment contract as an entity, right? However, that's not how things work in U.S. or Korean law, to the best of my knowledge. Um, Iron Mace is indistinguishable from Mr. Choi and Mr. Park because they're the owners of that company, right? They're the same entity for multiple purposes. Unless the courts specifically grant a motion that makes it so they're seen as not separate entities. But in that case, then Iron Mace can't be sued for IP that. So if Mr. Park and Mr. Choi are the ones technically infringing on the trade secrets, then Iron Mace can't be held accountable, and Darker should be moving forward right now. But Nexon wants Iron Mace to be so intrinsically linked to Mr. Choi and Mr. Park that Iron Mace can't release the game, right? However, they're arguing here that Iron Mace is a separate entity, and because it did not exist at the signing of the contract, that it's not linked to Mr. Choi and Mr. Park or this contract. So they can't have it both ways. And they're trying to have it both ways. And what they're doing, like, when you do this kind of maneuvering in court and you file a bit, because this is the same exact argument that they had in their original reply to the dismissal. It's literally the same verbatim, same reply. It's a stall tactic. And I just posted an article from the American Bar Association in my last video about how this can be a slippery slope and how this can get Nexon in a lot of trouble. So there's a fine line that they're walking with this, and if they keep pushing this process, they're going to get in trouble with the court. Like one reply is fine, and this might lead to like one verbal argument between the two and the two parties and the judge sometime before the 21st, maybe like tomorrow. Hey, bird, that's my straw. But what up, Sebastian? But yeah, this is a very slippery slope for them. Please do not knock over my water. That is a full water. Sorry, guys. A cat is walking all over my desk. What are you doing, bird? Oh, here. You want me to throw the thing? Come here. Come here. Go get it. Good girl, bird. Yeah, they can't have their cake and eat it too. What up, Liv? That's my moderator. Be careful. She'll kick you guys out. What up to the 71 people? Yeah, if somebody, I don't know if anybody can like post like a quick TLDR, I'll pin it. Thanks, Nobushi. I appreciate you. So let me keep going. International jurisdiction. Professor Lee advances an argument that the form selection clause falls under international jurisdiction based on the flawed premise that the clauses were intended to cover post-employment tortious conduct at Iron Mace that impacts other jurisdictions like the United States rather than Choi and Park's employment in Korea. Again, they're trying to reiterate that same thing. Professor Lee's opinion is unsupported by evidence and contradicts defendants' original contention that this is an exclusively Korean-centered dispute, because defendants knew they were seeking to enforce Korean contracts when they filed the motion. Defendants should have included these lengthy arguments in their motion rather than reserving them for a reply. So this is kind of also a contentious argument that they're making themselves, because all of these arguments that Iron Mace made in their last reply, Darkology. Yeah, I'm Professor Derp, PhD of Darkology, Dark and Darkology. So essentially, in this intentional jurisdiction section, what's happening is, or international jurisdiction, they're claiming that the Professor Lee, I think he was the language and like law expert, is trying to say that the contracts don't apply to Iron Mace. But so they're doing that same argument. Um, but they're also trying to say that he kind of missed the point because uh, the contracts weren't supposed to cover, they weren't intended to cover post employment. Um, so if you notice that it says intended in both their opinion and his opinion. So in his opinion, he states that they were intended to cover post employment. Uh, according to um, Nexon, it's unintended, but that's not a fact. So intention is everything, right? Um, just because somebody intended to do something doesn't mean that they actually did it. Just because somebody didn't intend to do something doesn't mean that they didn't do it. So you have to be direct in their language, and you have to pick apart each word. Like, what is an argument? What is a forum selection clause? What is international jurisdiction? Because I have this in quotes. You have to pick apart each one of these words. So post-employment tortious conduct is a very specific term, and they're saying that at Iron Mace, not even Nexon, um, post-employment tortious conduct at Iron Mace that impacts other jurisdictions. So they're trying to say that something completely unrelated to Nexon has any bearing on Nexon suing Iron Mace, and that's just not the case. Either this is a typo, or they're just trying to conflate issues and kind of muddy the waters. Seeking to enforce Korean contracts when they filed the motion, defendants should have included these lengthy arguments in their motion rather than reserving them for the reply. So they couldn't have they couldn't have included these in their original motion because the argument hadn't been made yet, right? Nexon hadn't filed their response, and we don't know what happened in the phone call between. We don't have any direct quotation from the phone call between Nexon's lawyers and Iron Mace's lawyers, so we don't know how that conversation went, and neither does the judge unless they have handed over some kind of recording. So this 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 entire paragraph is basically just them muddying the waters a bit more. Um, a lot of this sounds very valid and very damaging. So like it would be like, if true, some of this stuff is like not good for Iron Mace. But if you look at the real like the wording, and I'm sure that like my friends who are lawyers will look at this and be like, yeah, you're, you know, maybe not 100% right. I'll probably be corrected on some of this stuff, but from what they've taught me and from what I've studied on my own, and back when I was helping my friend Nick's mom study for the paralegal exams, like, this is what I've learned from contract law and from having written my own contracts and stuff like that, and having them looked over by lawyers. Like, what I know from contract law is words. Each individual word is super, 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 super important, and you have to take all of this stuff into consideration, because if you don't, you'll kind of miss the forest for the trees, right? So, um, yeah. So they're saying that the scope of the selection clause doesn't matter, or isn't what they're stating. Here, let me see if I can pin this. Boom. Phantom gets a pin. What up, Michael? Welcome to the stream. Bread Toast, welcome. So what I mean by muddying the waters is like obfuscation, right? Like they're making some facts, and yeah, so this is a new document. This was posted maybe like 30 minutes ago at this point. Yeah, you have to mean what you say and say what you mean in a contract. There can't be any ambiguity. So, and there should be, and the thing with contracts and contractual obligations and court filings like this is like, you have to assume that the automatic assumption that the judge is going to have and lawyers are going to have is that every word is intentional, right? They're going to go into this with everything is as written, and if it's not, then something has to be expanded upon, or uh, you have to dig into it, or you can expect that that wasn't the case, right? Or that it doesn't have any bearing on the case. So the words that you put in these documents are extremely important, because if you say something that's not true in here, or if you bend the word, or if you like imply a meaning without expressly stating it, that meaning can't have any bearing on the case, like legally standing. But yeah. So, but yeah, mudding the waters is basically like making things unintentionally vague and hard to determine, right? It's like imagine having a clear pond and then you throw a bunch of dirt, but a clear pond with like a treasure at the bottom, and then you throw a bunch of dirt in it, and now you have to go find it, right? It's going to be a lot harder to get to that treasure than it would be if the pond was clear. So muddying the waters is just a term for um, making things more difficult to see. Yeah, so I'm intentionally trying to slow things down. Now, source code production. This is what I thought that they would get into, right? This is what I thought that they would try to strike, but they're actually trying to strike basically the entire last reply, which is a little overreaching, and this will probably get them because they're trying to do so much. It might get this motion thrown out like immediately. Defendant's motion falsely claimed that Korean judges were reviewing Iron Mace's source code. False. That's not true. They never claimed that. They claimed that they could review Iron Mace's source code and that Nexon hasn't asked. So this is not true. I would like to see that quoted, but it's not. They cite the docket number right here, docket number 29 at 1. Rather than owning their own mistakes on reply, defendants lash out and blame Nexon for defendants' lack of production and accuse Nexon of bad faith, which is true. I mean, the lash out part is opinion, but blaming them for bad faith argument is true because it was, in my opinion, was a bad faith argument. Jian declares that Nexon should have employed certain Korean documents request procedures rather than seeking documents informally. If given the opportunity, Nexon would have explained that the procedures Jian cites are not used in practice in preliminary injunction proceedings because parties usually submit evidence they have at hand. So if given the opportunity, Nexon would have explained that the procedures Jean cites are not used in practice in preliminary injunctions. Doesn't this term in practice kind of negates the not used, right? In preliminary injunction proceedings because parties usually submit evidence that they have on hand because time is of the essence in a preliminary injunction proceedings. So the document request procedures are rarely used as they are too time consuming. Moreover, so what they're excluding here is that Nexon has had almost 2 years to get the source code. They've had access to this information since Iron Mace was raided. So this is kind of more muddying the water, more obfuscation, right? This is more of them, more kind of like trickery, because they're leaving out a lot of information here. Moreover, the procedures are likely inapplicable in merit, and preliminary injunctions, or moreover, the procedures are likely, not fact, this is opinion, likely inapplicable in merits and preliminary injunction proceedings to confidential source code. And if applicable, the sanctions on defendants for noncompliance would be ineffective. So this is all opinion. All of this is opinion. I don't see any fact. The words likely and most likely and would be, like that's all opinion. Nobushi. So they took all their code when they got raided. So they've took laptops, made copies, all that stuff. So all the hard drives that were at Iron Mace were taken and copied. So they have access. Nexon has access to all that. As the plaintiff, Nexon has argued, especially in a criminal case, because that's related to a criminal case against Mr. Choi, where Mr. Choi can go to federal prison in Korea. So Nexon has access to all of that information and has never, according to Iron Mace, has never once asked for it in the 2 years they've been in a court battle with Mr. Choi. So they've never asked for that information once. So defendants knew they had the burden of proving Korea as an adequate. Also, the burden of proof in Korea and the United States is on the plaintiff. So If they want information, they have to get it themselves. So they don't make any mention of that. Just because Iron Mace didn't willingly give Nexon directly their source code doesn't really mean anything. It means, or the court directly, because nobody ever asked for it. It's like if I was being sued by Nexon and they said, "Hey, we want evidence that proves you're guilty, give it to us." But actually no, they don't even ask for it. Say I had evidence that proved that I might be guilty, right? Not saying that Iron Mace is, but say I had evidence that would help Nexon's case. If I was being sued by Nexon, there's no way in hell that I would go out of my way to give any evidence to Nexon. They would have to ask for it and legally order me to give it to them. Because helping them at all is against my own best interest in any court case. I'm not going to go drive up to a cop and be like, "Hey, do you want to search my car?" when I'm like not doing anything wrong, just because I feel like it. No, that's ridiculous. So who's going to win this case? I honestly think it'll settle in probably the next few months. That's my honest opinion. So technically, Nexon will win because they're going to be the ones in charge of the settlement agreement. But we'll still get dark and darker. But yeah, this is so it's two kind of time-consuming procedures like this. Blah blah blah. Defendants knew they had the burden of providing Korea as an adequate forum. Oh no, wait, hold on. If given the opportunity, is this where I left off? Yeah, if given the opportunity, Nexon would have explained that the procedures Jean cites are not used in practice. Okay, in practice, really time-consuming. Moreover, the procedures are likely inapplicable to merits. Defendants knew they had the burden of proving Korean as an adequate forum on their non-production of source code was hotly disputed, rather than falsely suggesting that they had already provided the Korean courts Iron Mesa source code and manufacturing a distorted excuse for non-production in reply. Defendants should have included their position in their moving papers. So this is really the only argument that they have. So the rest of this is opposition by opinion. And this right here, this statement right here, is their actual argument. Rather than falsely suggesting, so falsely is also an opinion, rather than falsely suggesting that they had already provided the Korean court Iron Mesa source code and manufacturing a distorted excuse for non-production in reply, defendants should have included their position in their moving papers. So their actual argument is that Iron Mace should have said this when they asked for the dismissal or in their original reply to the case, which is just not correct because they weren't even asked about it. You can't answer questions that you're not asked. Yeah, I also think that Nexon is trying to sell the rights to P3. And like it seems like they might be trying to sell the rights to P3. They might not want to produce it themselves, but they might have a buyer for the rights themselves. And in order to sell the rights, they would need to get some kind of judgment, whether it be a settlement or a win on this case. So language of source code, defendant's motion falsely claimed that Iron Mesa's source code is in Korean. No, they said that this is kind of vague because they didn't say that the source code is in Korean. They said that portions of the source code are in Korean, including notations. So on reply, Park submits other evasive declarations claiming Iron Mesa's programming notes are in Korean. See, so this statement is completely refuted by this statement directly after it. Programming notes are in Korean without taking a clear position on source code. Park's testimony on whether the contents of source code and programming notes are in English or Korean is inadmissible. Defendants have the burden of establishing a clear showing of facts, entitling them to dismissal. So they cite these cases again without actually quoting them. Defendants' sandbagged declarations cannot meet standard and should be stricken. That's it. That's really it. And they've probably attached a motion to strike, which I think they have. So let me pull that up. Yep. They've attached. So this isn't granted. It says granted on it, but don't worry. This is just something that Nexon wrote up to, kind of like how Iron Mace did. Um, yeah, Nexon is basically copy and pasting this. Um, so yeah, Red Coin Co. The remainder. So any remaining pretrial hearings will happen on the 26th. So we'll know by the 27th of what's going on. Yeah, bread toast. I think Nexon and Ion will settle. Well, there comes a point in time where both of them are going to run what's called a cost benefit analysis, and it's going to weigh the cost of continuation of the trial versus the benefits of continuation of the trial. And at some point, the cost is going to outweigh the benefits, right? And at that point, it's just best to cut your losses and settle, regardless of how much money you get. So usually, what ends up happening is both parties start out as like Nexon wants $1 billion, Iron Mace wants to pay nothing and win, right? And then eventually the costs start creeping in and the timeline starts closing down, and you get closer and closer until to an actual trial. And then what ends up happening is Iron Mace is willing to settle for more and Nexon is willing to settle for less, and then they meet in the middle, right? And because neither party wants to actually go to trial and lose, so because not only if they lose, they'll have to pay all of their own court fees, but they'll also have to pay some kind of settlement. And if Nexon loses, they could probably be countersued by Iron Mace. So, and they might end up having to pay all of Iron Mace's court fees, right? So it's really, really, really a matter of, like, in my opinion, when they settle, not if. Um, I'm not some kind of soothsayer. I can't see the future, but um, yeah, this, in my opinion, is a settlement case, and all of this stuff is basically what it looks like. What do I think? I think that I think that'll happen in the next few months. So I think it's something like 80 to 90% of all cases settle during discovery, and discovery is over by the end of October. I'm pretty sure if my math and if my math is correct, the last day of discovery will be somewhere on or before November 21st of this year. So then it goes to a year-long period where they could do, like, basically they have a date to where they can set um, a year out. So after November 21st, they have to come, like, decide on a date of when the trial is going to start. So, and that could be up to 12 months later in Washington. So um, it really depends. It really depends on how long both people want to wait. And then they can still do fact finding while that goes on. If they find anything that's super important, they could file for a motion to have it included in the trial, but it has to be approved by the court and signed off on by the opposing party. The Korean case. So what'll happen is if the U.S. case settles, excuse me, uh, if the U.S. case settles, they will most likely, like 99% of the time, they will. Um, no, so this isn't actually granted. If you notice, it's not signed. This isn't dated or signed. So this is just a document Nexon wrote up to have signed by the judge, but it doesn't mean that it's been granted or denied yet. Um, so, but to finish my statement, like 99% of the time, if there's a settlement in one district or one country, it'll include a settlement for the any international settlement too. And what they'll end up adding a clause that'll say, like, you can't talk about the settlement. So there'll be an NDA attached, as well as a clause that makes it so that they can't sue each other over this same thing again or something related to it, like, ever again. So it'll be settled, like completely settled. And then if somebody breaks the contract, they could come up with a contract dispute and sue each other for the violation of the contract. But for, like, this exact same matter or something similar to it, they can't if it's related to this case. So this this document is basically written by. So if you look at it, Um, it says it's proposed, it's not granted. So this is proposed. This is the language says granted, but it actually hasn't been granted. So this matter, so this is what Nexon wants to happen, not what is actually happening. This matter came before the court on plaintiff's reply to strike matter filed in connection with defendant's motion to dismiss on grounds of forum nonconvenience, motion to strike, and having considered plaintiff's motion to strike, the paper submitted by defendants in support of the motion to dismiss on grounds of forum nonconvenience. So this is actually not very well written either, because they're asking to have all they're asking to have the entire motion to strike motion the entire motion to dismiss stricken, as well as all of the documents that were supplied from it. The papers submitted by defendants in support of, so the entirety of the dismissal and all of the evidence with it. So I highly doubt this is going to happen. And blank from grounds of forum nonconvenience and blank. So anything they add afterwards. And being familiar with the pleadings and filing of records, the court is fully advised. Now, therefore, the plaintiff's motion to strike is granted in its entirety. The following material is hereby stricken from the record. Paragraph 7 of the declaration from John B. Duncan. Paragraphs 5, 7 through 21, 23 through 24 of the supplemental declaration of Youngjun Jean. Paragraph 2 of the supplemental declaration of Terrence Park. Paragraphs 9, so the entire paragraph, paragraphs 9 through 19 of the declaration from Professor Gyuhu Lee, the portion of defendant's reply brief, docket number 45, replying to foregoing, namely 6, 1 through 2, 7, 4 through 9, 7, 21, blah, 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 and the footnote 3, dated this day of this day, Honorable Tana Lin, but it's not signed. So this is presented by Stokes Lawrence PS. So it was written by Joshua Harms. And then noticed by Shane and Joshua Harms. But it hasn't been signed yet. So, yeah, there's no way in hell. That's like basically almost the entirety of that last reply that Iron Mace sent. There's no way that they're going to get all that stricken. There's no way. I see they attached a really weird declaration by an 18-year-old lawyer for Nexon's case. What? Honestly, Blackburn, I don't know why Blackburn didn't write this. Blackburn might have been shifted to handle their you saw a declaration on court listener? Here, let me look that up. Oh. Yeah, right here. That's new. So let's read through this too. Declaration of Mijun Park. So I will open this up real quick. So here's the declaration. Oh, this is a scan. That sucks. Oh, it's only 2 pages. In support of plaintiff's opposition to defendant's motion for relief from the I, Mijun Park, hereby declare as follows. My name is Mijun Park. I am over 18 years of age. The facts stated in this declaration are known by me personally to be true and correct. If I call as a witness, I can testify, blah, 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 blah. My firm Kim and Chang, and I serve as counsel for Nexon in the legal proceedings in Korea as a defendant. I previously submitted a declaration describing my background in the legal proceedings in docket 41. The Suwon court has set July 19th as a deadline for parties to submit final briefs for the preliminary injunction application proceedings. After the court set deadline of July 19th, 2023, parties will await the court's decision. The court is not required to consider any briefs filed after July 19th, although the parties are not prohibited from filing additional briefs. Based on my experience and the nature of parties' applications, I anticipate it will take 1 to 2 months for the court to reach its final decision in a preliminary injunction proceeding. No hearings on the merits litigation between Nexon and defendants have been scheduled, and the court has not invited any briefings at this time. I declare under penalty of perjury of law, Mi-jung Park. Executed this day, the 19th of July, 2023 in Seoul, Korea. So, yeah, I saw a news article that cited this, which is funny because this must have been written in Korea as well, and then translated to the to English. Yeah, pretty much translates that last paragraph of the news article. So the issue with the month to 2 months thing is I don't know how the scheduling works in the US, in the United States. The scheduling works like this. Usually it's like, depending on the district, it changes, but usually it works like 60 days from this date or 30 days from this date, whichever is sooner. So if that is the case for Korea, then it will be an earliest of 2 dates, either probably 60 days from the start of the investigation or 30 days from the end of the investigation, whichever is sooner. So I only know when the investigation ended, which is the 19th. So today, or technically yesterday in Korea now. So we'll have until the 21st of August at the very least as like the honor before date. But keep in mind that it can happen at any point before that as well, right? So it can happen sooner than those days. Yeah, so there's no hard date, nothing's been scheduled yet, but as soon as we get a schedule, I do have access to some dates and some of the documents that are filed in Korea. So it's like I see a list of all the documentation. I just can't click on the documents. They won't open for me because I don't have access. I'm not a member of the Korean legal world, right? So all that said and done, what's the earliest and when's the latest the game you said? So in my opinion, I think that we might see early access sometime before. So if the case gets dismissed, which I still think is unlikely, there's a small window where it would be perfectly legal for Iron Mace to release early access and not receive a DMCA until they heard the decision back from Korea anyway, right? So if the case in the United States gets dismissed on the 26th, then Iron Mace could theoretically release early access and Nexon wouldn't be able to DMCA them until they filed an appeal and were granted an appeal. So, and that would take like a month or two, right, for the case to start going. By which time the injunction in Korea would have happened. So there's a timeline where if the case does get dismissed in the United States or an injunction happens on the 26th, then they have like basically a month to appeal, right? It takes 30 days to appeal usually. So the appeal process for the appeal to start. So I think it's unlikely that the case is dismissed. I think that there's a better chance of it being dismissed. My original percentage of it getting dismissed was like 10%. Not likely at all. my percentage now is like 20 to 25. So it's like more than doubled because I think that Iron Mace is like gaining ground to get a dismissal through, but I still think it's a long shot. Just because dismissals aren't that common. Not this type of dismissal. Settlement dismissals make up a large majority of all dismissals. Um, I think that there's like a 25% chance that this gets dismissed, so not very likely, but better than nothing. I think that there's a very high likelihood of a modified injunction going and being put in place in Iron Mace's favor. So what I mean by that is I think that Iron Mace will have a favorable injunction placed against like Nexon, so Nexon won't be able to send any more DMCs, thereby allowing Iron Mace to release early access. But the Iron Mace will probably have to put up a bond, which would be probably it would be whatever the like cap, whatever the maximum damages are for this case, is what Nexon is asking for. Iron Mace would have to put that up as a bond in order to release early access. So, and that injunction should be decided on the 26th. The early case conference is on the 26th. And basically what the early case conference is, it's where all the pretrial hearings happen. On or before that date is when all the pretrial hearings happen. So like we're having motions being put forward through already, and they're already holding arguments, right? So 26th of July, so in like literally 7 days. What up, chicken fries? What up, tough RPG? So this month in like 7 days, is when I think that I'm fairly certain that's when the injunction should happen, on or before that date. So if we get a dismissal on that day or an injunction on that day, then there's going to be a window of 30 days where it's going to take like 30 days for at least 30 days for Nexon to appeal, right? And that gives Iron Mace time to release EA without being DMCA'd, because they can't DMCA during that period. Nexon can't, because there's no legality behind it. They can't put a case forward, so they can't apply the DMCA for like a month, right? So, and then if the injunction sticks, they wouldn't be able to apply a DMCA until some kind of opposition in Korea happens, right? So there would have to be two conflicting rulings, one in the United States, one in Korea. Yeah, so they can be on Steam with pending litigation. What a preliminary injunction does is it basically sets up a ruling for a temporary restraining order. So it blocks. So both parties are asking for temporary restraining orders against each other. That's what an injunction is. And Nexon wants a temporary restraining order against Iron Mace for them to stop sales and production and distribution of everything related to Dark and Darker. Iron Mace's injunction request is against Nexon to stop them from doing anything that interferes with their sales or distribution or production of Dark and Darker. So DMCAs, all that kind of stuff. And what a preliminary injunction does is it basically says, okay, here's the rules for this case, for the duration of this case until trial is over or you guys settle. And then once the trial is over, however that verdict happens, a permanent injunction will go into place against one party or the other. Whoever wins will have their permanent injunction put in place until it is either appealed successfully or forever, right? And then there's two appeals processes that they could go through. It's like, simply put, it's like local court, regional court, and then Supreme Court, right? For both US and Korea. And they both have a two-part appeal process. But yeah, Savior, so if an injunction happens, so if that temporary restraining orders, it would be sold on Steam. If Iron Mace has a favorable injunction hearing, so like if they get like either a full injunction against Nexon or a modified injunction against Nexon, to where like they have to put up a bond, they'd be able to release on Steam because Nexon wouldn't be able to DMCA them anymore. If an injunction goes in place or the case is dismissed, Nexon cannot DMCA. Like they can't until they appeal. They would have to get a successful appeal on July 26th. So the only way that Nexon, or the only way that Iron Mace would be able to appeal would be they'd have to go through the World Trade Organization or the World Intellectual Property Organization or the Hague, which takes months. Google Bard AI just said FNC dismissals happen about 52% of the time. I've never looked up the specific percentages. So like for FNCs, I've never looked up the specific. I've only looked up dismissals versus settlement dismissals and stuff like that. But yeah, they would be able to. I mean, these were pretty short documents, so like I'll just kind of do like a Q&A right now. Answer any questions. Maybe I'll jump in. Like, should I jump in a game and answer some questions? What's something easy I could play while I answer your guys' questions? I'll play some TFT because that's like super slow. Hey, bird. Said it was a study. PB and James, can you link that article or that study? Because I would love to look it over. I've never really looked up. Um, oh, I'm not gonna do ranked. You can't get me with that shit, Riot. I ain't gonna play into your ranked. What the hell is Soul Brawl? Love the new set. Thanks. This is all because of the War of the Andrews and Mike D, and blank blank. All the guys who have been giving, like, donating through subs and like memberships and on Patreon, like, you guys upgraded my setup like huge. I do want to get another light, but I think after I get a light, I'm pretty much done. Other than like fancying up the background and stuff. Thanks, Dusty. Yeah, so like I want to do like a poll. Um, I missed one. What did I miss? I think that I mean, honestly, um if PB and Jams is correct, then I think I think there's a good, like a way better chance of this getting dismissed. But I would love to look at that article. Um, if I could get a link either in Discord or whatever. That's so Nam, that's the early case conference. Um so all of the pretrial hearings happen like on or before, unless they're requested by a special motion, all of the pretrial hearings happen on or before the early case conference. There is a world where it is entirely possible that if the case is dismissed or Iron Mace gets an injunction, there's like a 1 to 2 month window where Nexon wouldn't be able to send DMCA's. So like at all. They would have to, like, if they tried to send a DMCA, they would have to get it through the Hague or the World Trade Organization, or WIPO, the World Intellectual Property Organization, because there is still a pending case in Korea, so they could use that to get a DMCA in the U.S. But they'd have to go through third parties. That's the one. Response by plaintiff Nexon Korea 44 motion relief. Let me look it up. Response by plaintiff Nexon Korea Corporation 44 Motion Relief Initial Discourse Deadline for a protective order to stay discovery pending resolution of motion. Oh, number 51? Is that what you're talking about amongst us? Because I already read through that one. This one? Right here? Yeah, I already read through this one. So yeah, there's a TLDR at the top. So the TLDR is basically Nexon is trying to have fair portion of Iron Mace's latest reply thrown out using the same sneaky language and muddying the water tactics from their previous statements. A lot of their arguments are basic. Yeah, so the Sir reply is basically them reiterating a lot of the same topics and then refuting a few of their arguments, but using unclear language and not really. They're not really. They cite a lot of legal precedent and they quote a lot of stuff, but they actually don't do what's called an interior quotation. They don't actually quote it. They just cite the case and the number in the paragraph without ever putting in quotes what part that they're citing, right? So it's it's it without trying to be like too biased towards Iron Mace. It's kind of it looks like it like to me it smells like a stall tactic and like a kind of a Hail Mary. Yes. So bread toast. If the case is dismissed, I'm fairly certain that Nexon couldn't send a DMCA until they're granted an appeal. So that because there has to be a possible threat of a lawsuit for the DMCA to have any validity at all. Because if they can't threaten with a lawsuit and they can't bring forward a suit, the DMCA terminates after like what is it, like 16 days or 21 days? It just self terminates. So they have to bring forward a lawsuit, otherwise the DMCA has no backbone. That's up to Iron Mace because there's still a pending case in Korea, but they will have a window of like a month or 2 months to. So the way it works out is if the case is dismissed or they get an injunction in the U.S. So like if Iron Mace has either an injunction placed against Nexon or a modified injunction placed against Nexon, or the case gets dismissed, one of those three things, there's going to be like a 30 to 60-day window to where Nexon cannot file a DMCA. It won't have any validity. Any DMCAs they try to send out won't have any validity. What up, Spooky Skeleton? Tweet, what up, John? Yeah, the injunction chance. I mean, a modified injunction is like the most likely outcome, right? In my opinion, I think I'm. So the existing DMCA is already irrelevant because of the case. The reason why a DMCA is still a threat is because there's an existing lawsuit, so a DMCA goes into place automatically. So if say if Steam put Dark and Darker back up, um, the second that Nexon DMCA'd them again, Nexon Iron Mace would have to pull it down, otherwise Nexon would immediately sue them because there's pending litigation. Yeah, I covered everything. Phantom. Oh, is it on Pacer? So no, there's only three things. Yeah, see, I've covered all three of these. So the plaintiffs are reply to strike. So this is number 51. So this is number 51. I've covered this. This is number 52. I've covered this. And then this is number 53. That's the only things I'm seeing on Pacer. Everything else is from the 17th or 14th. Let me see if there's anything on the calendar, though. The calendar might have been updated. Nothing. So we have noting date 7/14, noting date 7/21. Okay. They filed their thing today. FRCP conference deadline. That's the ECC, which is 7/26. Initial disclosures deadline is 8/09, so that starts discovery, and then joint status report is 8/23. Yeah, nothing new on the deadlines. Nothing new that I haven't covered on Pacer. At least that I can see. Yeah, so this declaration is in support of the plaintiff's opposition to defendant's motion for relief. So that's for this. Plaintiffs reply to strike matter filed in connection with defendant's motion to dismiss on grounds of forum nonconvenience. Right? So that's to this. I'll double check. Or did I miss something? So okay, so I have Oh, I did miss something. So there's a 20-page document. Get out of here, League of Legends. Plaintiff's opposition to motion to stay discovery. That's what I missed. No, don't open here. Sweet, good catch. And then there's also another one. Download this too. Sweet. Looks like we have a little bit more to cover. Good catch amongst us. Got a bunch of messages. Thanks, Diablo Chew. Thanks for watching. Yeah, I don't know if I saw your messages or not. Cool. I see it now. I'm just reading through these. Thanks for the screenshot and the link, T-Boy. Yeah, let's read over this document then. Cool. Sweet. You're enjoying the slow chat before the channel gets too huge. Yeah, I'm gonna read through that study, and if that's true, then I will I'll adjust my 20 to 25%. But yeah, if that study is likely, because you don't know what percentages they're using, right? It might be like 52% of the time when this or this happens, right? But there's like a very low chance, because first you have to factor in how often an FNC is actually asked for, and then how many times. Like, there's all kinds of different stuff that can affect the percentages. What content will you be making when the game is out? Um, so yeah, I'll answer some questions before I get into reading this. I plan on making like build guides. Um, I might do a little bit of gameplay, but I don't think I'm gonna flood my main channel with gameplay content because, to be fair, I'm not like the best at. I'm not like the best player, right? And if you guys want to watch gameplay, um, like there are people who are just really, 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 really good at the game. I am good at math. I know how to do research, so like infotainment is kind of my lane. Um, and I think like build guides would be good for me. It's what I did on New World and stuff too. I'm pretty good at getting like condensing information of like, hey, here's what works, here's what doesn't, right? And like mathing stuff out and then making the build guides is good. Um, and then I also plan on doing like new, like just gaming news in general. So like any Dark and Darker news, like what patch notes and stuff like that do. Um, I want to do stuff like I want to make a video about the cycle closing, because I actually played the cycle a lot. Um, News around the game and other games, and like build guides and stuff like that. Just kind of all different gaming related stuff, but mostly in the like informational side of it. Um, I'm not like the only game I would say that I'm really good at, like good enough to probably stream, is like Modern Warfare 2. I was like top 1% on Modern Warfare 2 like 3 years ago, and New World. I'm like, I ran one of the largest companies on the West Coast on New World. So like, I'll go clap cheeks on New World, but that game sucks now. Um, I was pretty good at Cycle too. So like Cycle, Modern Warfare, and like New World are like my top three right now. Unless Ultima Online comes back, then I'll wreck face on Ultima Online. Um, yeah, and if any games come out in like the medieval slasher genre, that would be cool too. Um, I was thinking about getting into Diablo 4, but a lot of people that I was going to play with are already kind of bailing on that game. They say they might play for like the first season, but they've already kind of got their money's worth, and then now they're like out. Yeah, like Rain's pretty much got the same idea. Like that's the same idea I have. Outlands is huge. I played Renaissance for a while. That was pretty cool too. I haven't played Outlands. I tried playing that Gloria Victis game too, but it was just like not. It didn't do it for me. That like MMO medieval siege game. It didn't do it for me. It was just a little too buggy. Based on information I have right now, I'd say like 20 to 25% for the dismissal. I would say like some kind of favorable injunction for Iron Mace is like 65 70. They put performance enhancing drugs, right? Um, when is the first playtest you played, and are you an early gamer for Dark and Darker? So I joined on the last day of playtest 3. That was I got like half a day on playtest 3, and then I like went crazy on playtest 4. LVO. So like, I would just say that it's kind of more of Nexon shenanigans. We have a TLDR of what's happened so far. I'm going to read through this other document right now, though. So this is their opposition to the motion to stay discovery. Yeah, this is 26th. We'll know by the 27th. Like either very late on the 26th or on the 27th. So this is the opposition to the motion to stay discovery. And they're saying, simply put, defendants Iron Mace Co. Limited, Mr. Choi and Terrence Park, collectively the defendants, are seeking to stay to delay the disclosure of critical information in this case. This is not surprising given their refusal to produce source code for their Dark and Darker game in the Suwon injunction proceeding in Korea, and it is inconsistent with their litigation strategy in this action. Defendants have filed a motion to dismiss the complaint of plaintiff Nexon Korea Corporation on forum nonconvenience ground. So, to avoid the U.S. discovery and consideration by a U.S. court of Nexon's federal claims. So, to sum up this little section, this is already a little bit misleading because they're calling the disclosure of source code critical information to this case, but they've never asked for it once ever, right? And they've basically all but admitted it that they haven't asked for it in the last documents we read, but they don't want that to be known by the court, so they're trying to strike that information. Yeah, they haven't even asked for source code yet, but they're claiming it's critical information in this so far. But they've all but admitted to not asking for it. But they're trying to say that Iron Mace shouldn't have said that. Essentially, basically, Iron Mace shouldn't have said that. The court isn't supposed to know about that. Please get rid of that information, and don't use that against us. Which is kind of hilarious. Defendants now move to stay discovery and all case deadlines pending to resolution of the FNC motion, DKT number 44 stay motion, because stays pending a motion to dismiss are the exception, not the rule, and because the relevant factors weigh against the stay, the court should deny the stay motion. White versus bond collectors, blah 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 blah. So they don't quote it. Before staying discovery, courts take a preliminary peek at the strength of pending motion to estimate the likelihood that a dismissal is a foregone conclusion. So they're conflating two different court cases. They're mixing two different court cases here, and they're not fully quoting them. Why do they do this? Just quote the actual case, not just 2 words from it. So this is 5 words, and this is 2. Like, not even a complete sentence. Defendants do not address this factor at all, nor any of the arguments in Nexon's FNC opposition, explaining why the FNC motion is likely to be denied. Defendants simply speculate their FNC motion might be granted, which is what this is for, which falls far short of the good cause standards for staying discovery. Edmonds versus Amazon Inc. Do they actually cite it? No. Moreover, courts do not typically stay discovery pending resolution of a forum nonconvenience motion because such motions are not case dispositive. They change the forum but do not end the dispute. Turner versus Costa Crocier. Denying a stay where action could be filed in Italy. That is the case here because defendants only seek to move the parties' United States law dispute to Korea, not end it. Yeah, that's the whole point. They want you to refile in Korea if you want to continue this lawsuit. That's like the entire point, and that's what they stated. There was a demo trailer that showed in-game footage of P3 a while back, so there was a build. Do you think any of what they are requesting to strike will be stricken? I don't think so. I genuinely don't. I think there's like a 30% chance that the strike that anything gets stricken from this. Their asks are a little too much. I don't know if I trust that given all their shady stuff with fake screenshots and other junk. This was way before any litigation. Okay. To some degree, they could at least get inside of a what looked almost like a pre-built level, and smash stuff. But that's not too hard to create, right? I don't think there was a lot of actual content in the game for P3. Defendants also mischaracterize their FNC motion as raising only strictly legal grounds for dismissal, but the parties sharply dispute numerous factual issues. Indeed, defendants' reply to the FNC motion effectively admits that the alleged factual basis for the motion is entirely in dispute by purporting to submit multiple new declarations on relief to clarify, explain, or outright contradict defendants' own factual representations in the moving papers. So they're saying that they're trying to claim that they're claiming that Iron Mace is speaking contradictory without giving any kind of, they don't quote anything that's contradictory. So this is all opinion based. So when you read statements like this, one thing to do is always look for quotation, because if there's not quotation and there's there's a bunch of opinion, that's basically nothing, right? You want to see fact-based opinion, not just, so like if this is true, where's the quotation that shows that they're factually misrepresenting themselves and submitting new declarations, and like where's the evidence? So if you make a statement like this in a court document like this, you have to state evidence. Otherwise, it's basically like, if I was the judge, I would just delete this whole sentence or this whole paragraph, because there's no evidence to back up the claim. Finally, granting a stay significantly prejudices Nexon because it delays a case that requires prompt resolution. That's opinion. Defendants, on the other hand, will suffer no significant prejudice from denial of stay. The task leading up to submitting a joint discovery plan, Rule 26F conference. So that's the conference on the 26th. I believe it's either the 26th or the, I'd have to look at the calendar. When's the Rule 26? Never mind. What up, Crab Street? What up, Corbin? Conference and exchange initial disclosures are not burdensome. Because defendants have failed to establish good cause for delaying resolution of the case, the court should deny their stay in motion. This is also opinion. What part of their argument hasn't failed to establish good cause? They can't, they're not even like giving a portion of the argument that they're saying is in bad faith or does not establish good cause. Nexon is a video game developer. Nexon formerly employed defendants Troy Park. We already know that. Secretly downloaded source code and other confidential data to his private servers. At the same time, Troy told his coworkers he had secured financing and solicited them to leave Nexon to develop a game similar to P3. When Nexon learned of Troy's solicitation, Nexon conducted an audit and that uncovered Troy's authorized transfers or unauthorized transfers. Troy's initially agreed to provide his private servers, but then his lawyers said don't do that to Nexon so that it could forensically audit them. But he reneged on this argument and deleted all of the data on them, as his lawyer and the contract that he signed told him to do, and he was still employed at this time. Subsequently, approximately half of the P3 team left Nexon, including Park and 2 other employees. who illicitly stole P3 data and now work for Iron Mace. They haven't proven this to be true. So this isn't proven to be true yet. This is a claim by Nexon. If true, this is very damaging. So if Mr. Park did in fact steal data with two other Iron Mace employees, if they stole data and took it to Iron Mace, that is very damaging. But this is yet to be proven in any of this investigation. So half the team did leave. Out of about 20 people, 10 left. Yeah, so like out of 20 people, 10 left. And yeah, so out of 20 people, 10 left, and the 10 half of those 10, all the newer 10 basically signed on to the project in the last month of it being active. And then the original 10 people left and founded Iron Mace is what happened. SDF is the best. Mr. Choi rules. In October 2021, Choi and Park co-founded Iron Mace between August 2022 and April 23, of course. Released a demo vision of called Dark and Darker on Steam, an online platform run by whatever. Strikingly similar to P3, defendants purposely targeted their marketing Dark and Darker at the United States, and the United States is by far their largest market. Nexon sent DMCA over a year later, and only a month after filing for their copyright, resulting in, yeah, we know that what happened there. Iron Mace responded by filing a request for preliminary injunction on April 10th, 2023, in Suwon District Court for an order under Korean law and joining takedown requests to Valve. Nexon responded by seeking a preliminary injunction under Korean law barring distribution of Dark and Darker. The defendants' FNC motion defendants argue the parties' dispute is subject to forum selection clause in Choi and Park's employment-related agreements calling for litigation in Seoul Central District Court. Contrary to their position here, Iron Mace initiated litigation in Suwon, not Seoul. So they're claiming that because Iron Mace initiated litigation in Suwon instead of Seoul, and defendants affirmatively took the position in Suwon that the Seoul court lacks jurisdiction, Nexon has submitted expert testimony on how the forum selection clause would be understood by Korean speakers and the court, which establishes that the clauses do not cover this dispute. Okay, we read that. They can't just assume guiltiness. That's a no-no in court, and the judge will probably call them out on it. You can't just assume guiltiness. Yeah, but nothing's stopping them from claiming it. Exactly. So there is no case. There is no cases against Mr. Park or any other employees in Korea. So what Nexon? So Nexon could assume their guilt all they want, but they haven't even. The thing is, what they're hoping, and this is me assuming on behalf of Nexon, is that they're hoping that Iron Mace won't respond to this because they don't want to get in trouble for what's called abuse, basically abusing the surreply. They don't want to get Iron Mace doesn't want to get in trouble for abusing the surreply motion. So they're probably hoping that Iron Mace doesn't file a surreply to this because it'll stall their attempt to get the discovery delayed, and it will stall the injunction and all that. So they don't. So Nexon probably knows that they're pretty much safe to say whatever they want. But an easy response to this is, well, if you think they actually did anything illegal, why haven't you taken them to criminal court for it in Korea? if they are guilty in your eyes, if your opinion is that they're guilty, and even if there's some kind of internal audit that proves that they're that you say proves they're guilty, why haven't you taken them to court and put criminal sanctions on them? Yeah, and Phantom, they don't really need receipts, right? Because they're trying to stall. So just making crazy, wild statements is enough to stall the courts. It's why this page is 20 documents and Iron Mace's page was 7, right? And we've already heard the same statement made 4 times in this. Nexon anticipates a decision within 1 to 2 months. There are no hearings currently on a calendar, and Suwon merits litigation between Nexon and Iron Mace. On April 14th, 2023, Nexon filed a complaint in this action alleging copyright infringement and trade secret misappropriation under U.S. law, which in my opinion is a wrongful lawsuit because they didn't violate the Trade Secrets Act in America, they violated it in Korea. On April 20th, 2023, Iron Mace submitted a DMCA. Counter notification consented to the jurisdiction of Washington. That's not exactly true, as proven in consent to Iron Mace's argument is that consent to a jurisdiction is not a consent to venue. So what Iron Mace is saying is that even though Western Washington has the jurisdiction, they have jurisdiction to handle this case, it's not the correct venue, right? So those are two completely different things, and that's part of their argument. That's part of Iron Mace's arguments of why that should be thrown out, of why it should be dismissed. And if you notice here, Nexon doesn't even mention that. What they do say is that the defendants do not contest subject matter or personal jurisdiction because they don't, nor do they argue Nexon fails a state to claim because they don't. All they're arguing is that even though Western District of Washington does have jurisdiction here, it's not the correct venue. They have jurisdiction over the DMCA because that's where Valve is. However, that doesn't mean that they agree to the venue of the court case. I think that some of this is valid, but I don't think that a lot of it will stand up to scrutiny. I think it's going to do its job and delay a lot of stuff. I mean, they could have already had the ECC and had a lot of the pretrial stuff already wrapped up if it wasn't for all of these motions, right? So Nexon is doing their job. The longer this draws out, the more money Iron Mace spends, and the more money Iron Mace is willing to settle for, right? Each day that passes means that Iron Mace is willing to settle for another dollar, right? But in this case, it's more like another $10,000. So every day that passes, Nexon gets another 10 grand, right? So that's what they're doing. Defendants do not contest subject matter. Yeah. So defendants filed their FNC motion. Defendants have also filed a motion to dismiss improper venue because this is what the defendants Iron Mace are actually claiming because that it's an improper venue. The court has set a deadline of July 26th for a Rule 26 FNC or Rule 26F conference, August 9th for initial disclosures, and August 23 for joint status report and discovery plan. Defendants have now moved to stay these deadlines and all discovery pending resolutions of the FNC motion. Defendants continue to express plans to release final version of Dark and Darker in the United States. Of course, a pending motion to dismiss is generally not grounds for staying discovery. It actually is. Let's see if they actually quote this. Oh, that is the quote. Pending motion to dismiss is generally not grounds for staying discovery. That's very vague because it doesn't say what type of motion to dismiss it is. It has nothing to do with an FNC. It just has a pending motion to dismiss is not generally grounds for staying discovery. So that could be in relation to anything, right? And unless they expand upon that, there's no way for us to know what they're talking about. The federal rules of civil procedure do not provide for an automatic stay of discovery when a dispositive motion is pending and they skip something, such stays can now slow down litigation. That is true. But it also has nothing to do with FNCs directly. We don't know what type of we don't know what portion this dismissal is coming, when what portion of the process this dismissal they're asking for is coming. We don't know what type of dismissal it is. There's a lot of information left out here and a lot of vague statements. These quotes are very loose. What do I think the likelihood of the judge believing any of this is? Not likely. Yeah, they could have. I mean, Iron Mace might countersue. They might not. They probably just want to wash their hands and be done with it. If they settle, they won't countersue at all. They would basically have to win this trial. They'd have to win at trial to get a countersuit going. And like I said before, I don't think they want to get to trial at all. Courts, however, may stay discovery under Federal Rule of Civil Procedures 26C for good cause, which, in my opinion, and the opinion of my friends who are actual lawyers, they have good cause. This mandate of a showing of good cause is critically important because Rule 1 of the Federal Rules of Civil Procedure advises that the rules should be construed, administered, and employed by the court at the parties to secure the just, speedy, and inexpensive determination of every action and proceeding, such as a dismissal. Friedman, as whatever. Thus, although any court may relieve a party from the burdens of discovery while a dispositive motion is pending, this is the exception and not the rule. Again, it doesn't pertain to any kind of specific dismissal, or we don't know what portion of the discovery this happened in the case. In deciding whether to impose a stay pending disposition of a motion, courts consider whether the pending motion will dispose of the entire case, and 2, whether the pending motion can be decided without any additional discovery. So this part is actually something that I've been thinking about a lot, is that the stay, if Iron Mace is going to have their request for a stay declined, it's going to be because any discovery done now in the United States would be able to be used by Nexon in a refiling in Korea. So just because the discovery isn't important to this case specifically, if the case gets dismissed, it doesn't mean that this type of discovery is not important at a later date in another case. And because it's an FNC dismissal, that means that Nexon is most likely going to refile this suit in Seoul. So that's the only reason why I don't think that the stay might be granted, because the discovery process is there to gather information, regardless of whether it can be used right now or not. Right? If it's information that could be pertinent to this case, and an FNC, basically, to get an FNC, to the best of my knowledge, and this is what my friend Whitney said, and my friend Matt, and my friend Sean all pretty much agreed on this. If you file an FNC, you're almost assuming that the person that, if the FNC is if you are granted the dismissal, it means that it's an almost certainty that the person who is suing you in the U.S. is going to refile in the jurisdiction that's more appropriate, right? So Nexon will have saved a bunch of time going into the next trial by already having discovery in the middle of being processed, right? So that's an actually genuine argument for Nexon. Will it be enough? I don't know. I don't think so, but it's like the only argument that I could see holding water as to not stay discovery. At least that I've found. In applying this test, courts make a preliminary peek at merits of dispositive motion to assess whether the stay is warranted. Yeah, so they can also look partially into discovery to see if the judge might need to do a little bit of discovery process to see if the dismissal is actually valid or not, right? So that's also an accurate statement. Courts also can consider the prejudice to the plaintiff if in granting a stay, denying stay based on prejudice from delay, considering the risk of unfair prejudice to the party of opposing the stay. It's not much risk. Right? It took them nearly 100 pages of documents to finally have a valid argument. Exactly, though. So that's part of it, right? So they're basically paying their lawyers per hour to write these long ass statements and file up hundreds of pages. But the only real valid argument that they've cited is that I've seen over the past 3 documents is right here. And it's a fairly simple argument, right? And it's one that they should have made at the very beginning. But no, it's hidden in the middle of, in literally the exact middle of a 20-page document after 3 other documents, right? So, um, it's just kind of shenanigans, as I like to say. These factors mitigate any granting against granting a stay here. The preliminary peek at defendant's FNC motion mitigates against a stay. A court's preliminary peek into pending motion to dismiss is not intended to prejudice the outcome of the motion. Rather, courts take a preliminary peek at the merits of the dispositive motion to see if it appears to be clearly meritorious and truly case dispositive. So what they're saying is that if they want to stay discovery, they're going to have to look at the dismissal first, right, and make sure that it has any kind of merit, and there hasn't been a chance. So this is kind of another valid argument. There has to be a valid chance at the case actually being dismissed, and they haven't even had a chance to look at the dismissal yet. So how can they stay discovery until they know that there's any merit for the dismissal? But the timeline is so close that it almost makes this a non-argument, because it's literally happening one day and then the next day is the dismissal, right? So it's all happening within the same 7 days. So if anything, they should request for a delay or a hold on this. They should have asked for they should have asked for an extension on this motion, to to basically stay the motion to stay, right, is what they should have asked instead of a dismissal. But right now they're trying to get an outright dismissal of this motion, or to deny the motion. They're trying to get a denial of this motion to stay discovery, when they should have really asked for a delay, right? Another stay, like stay this motion instead of granting it on the 21st. Like wait until the 26th until we actually look at the dismissal, to grant this motion, because nothing is known about how likely the dismissal is to the judge. They haven't went over it in any kind of argument yet, at least to the best of my knowledge and according to this. So that's a valid argument, but it's happening so quickly that it almost doesn't matter. Thus, courts consider whether the complaint is utterly frivolous or dismissal is inevitable. Rather, it doesn't have to be inevitable. It has to be possible, rather than staying discovery in any case in which a purportedly dispositive motion not requiring discovery is pending. Here, defendant's FNC motion is not meritorious, according to them. The courts haven't decided that yet, so this is a bold claim, much less clearly meritorious. So 2 bold claims in one sentence. Moreover, even if it were granted, the FNC motion would not dispose of Nexon's claims. Rather, it would really only result in Nexon refiling its claims in Korea. Exactly. So they would refile the claims in Seoul, and they would still be able to use all that information. Defendant's FNC motion is not clearly meritorious. That doesn't really matter. Just because you guys haven't looked at it yet doesn't mean that it has any merit or not, right? They don't know. In the paragraph before, you're arguing that you don't have enough information, so how are you saying it's not meritorious? How are you saying that it's clearly not meritorious? That's opinion. Defendant's FNC motion should be denied on numerous grounds described in Nexon's opposition. These include, but are not limited to, DMCA contains a special venue. They've already argued that. When a statute contains special venue provisions, Iron Mace argued against this. So, but they're trying to have that stricken from from the court records. So this only holds true if that is stricken. So they're kind of putting the cart before the horse on that one. And they cited Halliburton again, which I think is funny because that case has nothing to do with this. I looked it up after that live stream. In exchange for availing itself of privilege of invoking the DMCA counter notification process, Iron Mace consented to this venue. No, they didn't. They consented to the jurisdiction. At 6, a bargain for consent to a venue should be enforced. True, but they didn't bargain to a consent to a venue. They did in their employment contract. They didn't in the DMCA. The DMCA isn't consent to venue; it's a consent to jurisdiction. It says so in the wording of the wording of the DMCA itself. In all but the most exceptional cases, in Atlantic Marine, that's not what Atlantic Marine says, and they don't quote it, or they do, but they quote it before. And they state, and if you notice, consent to a venue should be enforced isn't in quotations. The only thing that's in quotations is bargained for, and in all but the most exceptional cases. Venue, the word venue specifically, is not in quotations because that's not what Atlantic Marine says. Defendants seek to require Nexon to litigate in Suwon District Court based on form selection clauses they misleadingly characterize as Korean form selection clauses. They are form selection clauses. They argue that they're Nexon even argued that they're form selection clauses. What they're saying is that those selection clauses don't relate after after the contract is expired via Mr. Choi and Mr. Park being fired or quitting. But the clauses they rely on call for litigation in Seoul Central District Court. That is true. They call for Seoul, not Suwon. The defendants affirmatively took the position that Seoul Central District Court lacks jurisdiction. Not necessarily. That's a claim and opinion that hasn't been argued in court yet. The only thing that's been argued in the court, according to Iron Mace and Iron Mace's lawyer and sworn testimony, is that Iron Mace has sued. Iron Mace is suing Nexon in Seoul. Nexon chose to countersue Iron Mace chose to sue Nexon in Suwon because that's where Iron Mace and Nexon are both located. Nexon could have countersued Iron Mace in Seoul. They chose to countersue in Suwon. Thus, by their actions, defending effectively and conceding the form selection clause. So what Nexon is trying to say is that because Nexon countersued in Suwon, that Iron Mace agreed to basically make that contract not exist anymore. Defendants, which isn't true, in my opinion. It could be argued that, but that's up to the judge. Defendants effectively concede that the form selection clause do not have meaning. Defendants advance in their FNC motion. That's completely up to the judge, not up to Nexon. The judge can say if this contract is still valid or not. If the contract is still valid, then Nexon should move both of their cases to Seoul. If the contract is invalid, then Iron Mace cannot be held accountable for stealing trade secrets and IP. So therefore, this entire lawsuit is defunct. It can be argued that this entire lawsuit has no merit. So they're really treading a line here, because they're trying to argue that the contract is in place and it is not. And the only reason why Iron Mace violated trade secrets is because that employment contract stipulates what those trade secrets are. If that contract is not in place, then those terms aren't defined, legally speaking. They would have to use the federal ruling on that, which is very different than their contractual ruling. So if they look by federal rulings only and the federal legality of only, then Nexon's case is severely damaged, severely damaged, because maybe you're dramatic. I don't think it's likely fated, honestly. Judges are smart. Defendant's contrary argument relies on cherry picking possible translations of Korean terms into English. That's been refuted, and they're trying to have that reply thrown out, rather than attempting to ascertain the intent of parties. On reply, defendants have newly disclosed expert and a way better expert, by the way. Nexon's expert was just some dude who spoke Korean. Iron Mace's expert was the leader of the United States like Korean organization or something. I can't remember exactly what it was for like 16 years. And he's also a federally recognized uh, court translator in the United States. So like he is like the expert on Korean to English translation. And the dude that Iron Mace got was like some Korean guy that speaks Korean, and that's it. Like he didn't like his credentials were like not very good. Other than the one originally cherry picked, defendant's reasonably accurate. Proof of infringement of source code requires side by side comparison of Nexon and Iron Mace's source code. Then why didn't Nexon ask for it in the past year and a half that they've been criminally investigating Mr. Choi? When the cops actually have a copy of the source code, like the police and investigators over there already have the source code on file, Nexon has never asked for it. But defendants have failed to produce their source code in Korea, and a Korean court cannot effectively compel them to do so. All that is true. The defendants have failed to produce their source code in Korea to Nexon, and a Korean court cannot effectively compel them to do so without Nexon asking. Thus, Korea does not offer Nexon an adequate remedy. Defendants purposely target the United States for copyright infringement, even when the majority of witnesses. So yes, this goes back to my argument that if you steal a TV in Korea and try to sell it in the United States, it's two different laws that you're breaking. The copyright infringement for distribution of copyrighted materials is a U.S. violation. However, that's not what this case is about. This case has very little to do with the copyright infringement. It has a lot to do with the trade secrets. Trade secrets part didn't even happen in the United States. It happened in Korea under Korean laws. Even where the majority of witnesses and evidence are located overseas, the Ninth Circuit Court held that copyright cases concerning alleged unlawful activities purposefully directed towards the United States are more amenable to the United States. So true. So this is true, but this also has to prove they have to prove intent. They have to prove that Iron Mace intended to target the United States above all other countries, which is going to be very, very difficult unless they can go into some kind of file and where SDF and Terry basically say, screw all the countries, we're focusing on the United States for sale. You know, which is going to be incredibly difficult. There is ordinarily a strong presumption in favor of the plaintiff's choice of forum, making a grant of forum nonconvenience motion a rare occurrence. HGT Biocorp for internal quotation immediately, denying stay. They're not even going to attempt that. They don't want to cite their own. Okay, they don't want to quote their own citations. Because several premises of defendants' motions were misleading or false, defendants were required to submit 4 new evidentiary declarations, which are subject to a motion to strike. Subject to a motion to strike, sure. The courts just asked for another reply, or Iron Mace just asked for another reply, and it was granted. Defendants failed to address, because that's normal. That's like standard. This is opinion, except for which are motion to strike. Yeah, cool, like, whatever. Next on. Defendants failed to address a preliminary peak factor and instead simply speculate their FNC motion might be granted because it might. It can be. I mean, I guess this argument kind of holds water, but not very well. But a defendant's speculation is that its motion might be granted does not satisfy Rule 26C, good cause requirement. Yeah, it has to be looked at first. In light of numerous significant questions, the respect of the merits of defendant's FNC motion, defendants cannot establish good cause for a stay. It has to be looked at first. Defendant's FNC motion is not dispositive. It sure is. Defendant's stay fails on additional grounds. Unlike Rule 12b-6, motion that establishes a plaintiff no valid claim against the defendant, forum nonconvenience motion simply moves to cause a new forum without disposing of it. Thus, when a motion to dismiss does not challenge merits of plaintiff's claim, rather relies on forum nonconvenience, the first filed rule, this factor Why are they skipping step? Does not weigh in favor of granting a stay. Windsurf Marine. I would have to look at that. I can't comment on. That's when a motion to dismiss does not challenge the merits of plaintiff's claims. So the motion to dismiss, what they're arguing is the motion to dismiss has nothing to do with the actual challenge or the initial comments or claims, but rather relies on forum nonconvenience and the first filed rule. Okay. I'm not sure what that rule is. This factor does not weigh in favor of granting a stay. So I don't know what enough of that is to make any comment on that. Yeah, they're using arguments from courts from different jurisdictions, and they're also using arguments from cases that don't even apply to this case, and they're taking like one sentence out of it and then applying it to this case. So denying the stay because, so like this. So denying the stay because in the event the court dismisses the plaintiff's claims against Thorco Projects, plaintiffs will need to pursue the same claims against Thorco Projects in the London arbitration. Of course. But they don't say what happens. They don't say, was this granted? Was this not granted? They assume and they use this quote, but they don't quote any outcome. They don't quote any, there's no evidence. They're just quoting basically an opinion that was stated inside of this one court case. They're using an opinion-based argument from a court case to argue for their own opinion. It's like saying, like, if I said the sky was blue and Spooky Skeleton agreed with me, or the sky was green and Spooky Skeleton agreed with me, that doesn't make the sky green. You know, that doesn't make it true. Just because somebody else just because another lawyer in another case agreed with your opinion doesn't make that opinion any more valid, unless it was proven to be valid in court, right? So I don't understand what they're trying to prove here. I mean, I understand what they're trying to prove. It's just I don't get why they're trying to do it this way. For example, the defendant moved for a stay pending the court's consideration of the defendant's motion to dismiss on forum nonconvenience grounds, arguing Italy was a more convenient forum. So this is Turner. The court denied the stay motion because even if the court were to grant defendant's forum nonconvenience motion, the need for discovery would not be eliminated, as I said earlier. Rather, discovery would only be delayed because plaintiff would be free to refile the case in Italy. So they'd have to do discovery all over again in Italy anyway. So it would essentially double the cost. The parties dispute over the lease, whether litigated here in South Carolina or any other venue, will require discovery. So what they're saying is they could basically do the discovery once and do it in the United States because the United States is a valid forum for Italy. Pretty much every court in the world that follows any kind of similar rule will uphold our rules for discovery and stuff like that. So A&P is one of the top law firms in the world for getting settlements. They're not necessarily, from what I've been told, they're not necessarily known for winning. They're not known for winning. They're not known for losing. They're known for settling big ass IP lawsuits for a lot of money. So they are basically a cash extraction law firm. It's who the corporate bigwigs call when they basically just want to force a settlement on somebody and extract money out of them. That's what A&P does. Arnold and Porter, which is exactly what it seems like they're trying to do here. It's like it's like if you're choosing a batter in your batting line for baseball and you're trying to get people onto base, you don't put the guy who's going to hit a home run onto plate. You put the guy who's going to consistently get people to like second or third, right? And that's what Nexon wants, right? They want to get they want to get to third base and just sit there until the bases are loaded, and then they're going to try to hit a grand slam or just basically make it a tie game, because they get a lot of money from a tie game. So defendant's characterization of SSI, or U.S. Inc. versus Ferry, whatever, has granted a stay because of a pending forum nonconvenience motion is false and misleading. While the court stayed discovery because of pending Rule 12b6 motion, the court explained that the forum of nonconvenience argument is irrelevant to the court's decision on the issue. So this is the first relevant. These are like the first relevant arguments that they're making. That even if the case is dismissed on forum nonconvenience, that the evidence found in discovery can still be used. But they're making it 5 different times now. They've already made their statement clear, and it is true, and that is a valid argument. It's like the only valid argument I've seen from them out of this whole document. In fact, out of the last 3 documents, this is the most valid argument I've seen. Defendants also mischaracterized this court case as granting a stay pending on forum nonconvenience motion. The defendants in that court case did not move to dismiss on forum nonconvenience grounds. The defendant moved to dismiss for lack of personal jurisdiction. The pro se plaintiff responded by arguing Nevada was not a forum nonconvenience and that the plaintiff failed to oppose the stay in motion. So basically, they won because the plaintiff failed to oppose the stay. That's kind of a tit for tat, like non-argument. That's just like a haha, gotcha. That shouldn't really have too much bearing on this case. So they have one valid argument and a gotcha moment. Noted as a stay may be appropriate if the motion raises an issue of jurisdiction, venue, or immunity. Defendant's FNC motion raises none of those issues. Again, Atlantic Marine distinguishes venue, forum, nonconvenience motions, unlike jurisdiction, venue, and immunity motions, which attack the legitimacy of the court, even considering the case. A forum nonconvenience dismissal is a strongly disfavored discretionary tool for dismissing claims that are properly before the court. This is properly before the court. It's just in the wrong court. Because defendant's FNC motion can only change the forum rather than dispose of the litigation, this factor does not favor a stay. Okay. FNC motion raises factual issues, showing a lack of candor. At the same time, defendants were drafting full reply evidentiary declarations disputing facts. Defendants submitted a stay motion. This is a snooty way of saying that the last reply by Iron Mace was not classy, showing a lack of candor. FNC motion as strictly legal. In reality, the parties dispute a number of factual issues, including the meaning and scope of the forum selection clauses, whether defendants are stopped from asserting them, the language in which critical documents are written, whether United States litigation is beyond the means of defendants' financiers, and the location of third-party witnesses. So I don't think it's the place of Nexon to judge how much money Iron Mace has, unless they could get some kind of factual evidence that Iron Mace actually has a shit ton of money. This is basically a really complicated rap battle, basically. So before I read it into this page, I just want to say thank you to everybody who's been sticking around and everybody who's commenting. Mattel, Larson, Thick, Enrico, Crab Street, everybody who's sticking around. There's still like 78 viewers. I think at one point I had like almost 90. This is incredible. You guys are all amazing. The Dark and Darker community and the community that's been growing around this YouTube channel is like hands down the best gaming community I've ever been a part of. And I don't know, Wounded Healer, like thank you guys all for joining. This is just incredible to see. Like, this is a 2-hour live stream about me reading a case doc. It was basically a podcast where I read a court document. Um, and you guys are incredible. Thank you guys very much. Um, WLFY, thank you. Uh, I don't even know how to say that name. Mia Kelne, Cane Plants, right? We all just want to play dad, and this is how we learn what's going on, right? So I'd rather sit here and read it with you guys, um, and talk about it because I get some good insights from you guys too. The community gives me some good insights, and I get to like put in my opinion and help you guys out when I can. So like this is huge for me, and the fact that you guys are sticking around for like 2 hours to listen to me talk and read a legal document is insane to me. But I freaking love you guys for it. I'm just a normal dude trying to have fun and learn what the heck is going on with on one of my favorite games. But yeah, I really appreciate you guys. Yeah, we're all just here trying to learn, right? That's what like being a human is about, is trying to learn and finding topics that we think are interesting and growing and learning together. Um, that's what, in my opinion, like being a human is. So yeah, it's just really cool to see that. You don't really see that enough on the internet, and you don't see that enough in the gaming community. And I think a lot of people lose sight of the fact that there's still communities like this out there, that are just genuinely supportive and helpful and want to learn and grow together. But yeah, I love you guys. You guys are awesome. I'm gonna finish up this document. Um, let's get back to it. So denying stay where the motion did not raise pure legal questions, while court while the court should simply strike defendants' reply declarations and deny the motion on grounds of defendants have failed to meet their burden. Even if the reply declarations were considered, defendants are incorrect that a forum nonconvenience motion is one in which discovery is barred. Lacey versus Cessna Aircraft, um, whatever, denying forum nonconvenience motion pending discovery. Hey, look, they put the final verdict in one of these citations. Check that out. Thanks, Phantom. I appreciate you. Um, yeah, it Diablo. I'm like right there with you. It's refreshing. Like that's exactly good term. It's super refreshing to see communities like this still thriving. Um, yeah, and I think we all just kind of want to hang out with people that are like minded and want to play like the same stuff as us, right? So it's just been cool to see and just to like be a part of that. And I'm just honored that you guys are kind of making me a part of your routine and how you guys get information. It's really incredible. Thank you, Big Duck. I wouldn't be able to do this without all of you guys. Like the community is what makes this go around, right? I can't do it without you guys. So, um, thank you. Uh, Bruno, the best news that we have so far is that out of like 40 pages, 45 pages, Nexon has only made like 2 valid points. Um, is like the best. But there's a TLDR posted that doesn't cover this document, but all the other documents that we wrote are read through. Um, but yeah, a stay unfairly prejudices Nexon. So this is something I was concerned about, is that Nexon is going to have an argument that a stay is going to put them at a disadvantage because it's going to bar them from information, and might end up costing them money, and their lawyers are probably more expensive than Iron Mace's lawyers. Um, so it does kind of put them at an unfair disadvantage in the cost and like the cost and financial department, but they're already at a massively unfair advantage. So it just kind of balances the scales a little bit, not even a lot, right? So the court should deny the stay on the additional grounds that the prejudice to Nexon Forum granting a stay far exceeds any potential prejudice to defendants. Bullshit. From denying a stay, defendants seek to delay not only the commencement of discovery, but the parties' Rule 26 meeting and conference and subsequent report to the court. thereby in effect staying the entire case because nothing can move forward without forward except pleading issues until the case deadlines have been set. That's the whole point. The point is Nexon is a company worth $10 billion. Actually, not anymore. They had to give 30% of it away to the Korean government. So still worth that much, but they don't control all of it anymore. RIP. Uh, but yeah, that the entire point is to in this whole motion is to stall the discovery and put things on hold until they know if they actually have to spend money. But Nexon's lawyers are on retainer, so they're paying them regardless. Request negatively impacts this court efficiency by delaying preliminary proceedings necessary to move this case forward in a timely fashion. What up, Jay? Furthermore, a stay of the entire case is prejudicial to Nexon because defendants are continuing to develop an infringing game whose development was accelerated through the use of Nexon's trade secrets. That's what's called speculation and opinion until proven in court. Denying stay where harm is ongoing. Just last week, for example, defendants posted on YouTube a first look at a warlock character. Thus, any delay in the proceedings increases the likelihood that defendants will begin selling a complete version of the game before the courts can resolve this dispute. The need for a prompt resolution of this case strongly mitigates any stay. Then why are you writing a 20-page document when a 3-page document will suffice? There is reason to avoid delays in the litigation if possible. And why did you just submit a new reply if you're worried about the timeliness of this court case? Why are you delaying the court case through unnecessary server replies? Doesn't make sense. There is a reason to avoid delays in the litigation if possible, and stay of discovery at this time may be contrary to the interests of justice. That's just funny. On the other hand, denial of a stay does not impose any significant prejudice on the defendants, except, they're paying by the hour and they have a lot less money than you. Regardless of how quickly the court rules on the FNC motion, if the court rules on the FNC motion within the next month, defendants will need to engage a Rule 26F conference, serve initial disclosures, and submit a status report and discovery plan. None of these activities impose a significant burden on defendants. Then they cite an immigration lawsuit. Okay. Denying stay where the court had not yet set a discoverable schedule. Even if the court takes longer than a month to rule on the FNC motion. And even if the court were to grant the FNC motion, defendants would still, how can they even take longer than a month? I mean, I guess it can be delayed by the court. That's not likely though. So like the likelihood of this outcome is like very rare unless the court finds a reason to delay it. I guess the decision to they might delay the dismissal because of until they figure out what to do with this stay. That's the only reason why I could see the dismissal getting delayed past the 26th. Defendants would still not suffer material prejudices because such a ruling would only change the forum, not end the litigation. But discovery in Korea would be a lot cheaper because there is a need for a prompt resolution of this dispute, regardless of whether the resolution occurs in the United States or Korea. There is no good cause to put this case on hold while a forum determination is made. Again, discovery in Korea would be significantly cheaper. Flying a Korean-speaking person and hiring a translator that is certified by the court is infinitely more expensive than not doing that. Like what? Nor is there a likelihood that discovery will result in any duplication in the coming months. That's true. In the Suwon litigation, the parties are scheduled to file their briefs and preliminary injunction proceedings on or before July 19th. Already happened. After July 19th, the parties will wait for approximately 1 or 2 months for the court's ruling on the parties' preliminary injunction application. No further proceedings are on the calendar in Korea. Yeah, Nexon is legally stalling the shit out of this trial. That's their entire purpose, is to stall and to settle. replace pin message. So yeah, the TLDR is pinned at the top. Thanks again, Phantom. I appreciate you. After July 19th, they'll wait for 1 to 2 months. No further proceedings are on the calendar in Korea. There's also no likelihood that parties will retread what has already occurred in Korea. No witnesses testified in Korea. No witnesses testified in Korea. Am I reading this correctly? No witnesses testified in Korea, and the parties did not engage in anything resembling document discovery. Rather, the parties submitted written briefs along with evidence they already had in their own possessions. Oh, so Nexon gave over their own evidence, and Iron Mace gave over their own evidence, but neither one called forward witnesses. So this whole case is just cuckoo bananas. He said, she said. Neither one has. I mean, I guess it would be a lot more difficult for Iron Mace to have proof, or to prove that they didn't do it, versus Nexon trying to prove that they did, because all the evidence kind of points to them developing their own game, right? Because even if they used trade secrets, they still rewrote all of the code. That's not the argument. The argument is like they wouldn't have been able to put this together without previous knowledge of because that they got from already putting it together once. But yeah, to not call any witnesses from Nexon or Iron Mace, that's insane. So Nexon didn't even pull Iron Mace employees as witnesses, which they're legally allowed to do, because in the criminal case and in the civil case, they could have called forth witnesses that work for Iron Mace. No, this isn't 100 pages, but they've submitted well over 100 pages worth of documentation in the U.S. already. This is 20 pages long. And then the previous one was about 20 something long as well, and then there was two more that were like three or four. So this is about 45 pages, 50 pages maybe. Rather, the parties submitted written briefs along with the evidence they already had in their own possession, blah, 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 blah. Furthermore, parties in Korea have only litigated issues of Korean law. No work has been done on issues of the United States law because it happened in Korea. Thus, any discovery taken there will not be a redo of what has occurred in Korea. Moreover, the court denies defendants' FNC motion, which is likely given its numerous defects. The stay would prejudice all parties by imposing an unnecessary delay in the resolution of the dispute. You're not crazy. That so what they're citing is something called non-certified testimony, meaning that it is witnesses that are strictly being used in. So it's not testimony from Korea. It's witnesses that happen to live in Korea and might have worked on the case, but they weren't witnesses in the case. So this is essentially a case of this guy said this. Trust us, bro. Unless it's in a written document submitted to the court, any testimony that's in quotation marks is highly sus. In this, that says it's from a person and not a court case. And even the stuff that is from a court case, so like this stuff, they cite this case right here, this cost conscious stuff. We have no idea what this pertains to. It's just one word, cost conscious, that they quoted from a case. So they quoted that and the word anemic. So yeah, defendants' contention that they are cost-conscious defendants who will settle an anemic case to avoid discovery is contrary to the evidence. Citing Bell Atlantic, Choi has stated he obtained financing to develop Dark and Darker, and those finances, that was from his family, and those financiers have supported a team of 30 full-time employees. They only recently went up to 30, like not even a month ago. Apparently for more than a year. It was 10 people for almost a year, or 11 people for almost a year. And then they went up to 20, and now they're at 30. Even with no significant revenue coming in, see docket number whatever, 32, paragraph 16. The evidence is clear that defendants are backed by deep pockets, and defendants are, despite submitting 4 evidentiary declarations on reply, have submitted no evidence that litigating this case pending determination of FNC motion is outside of means of their deep-pocketed backers. Says the company worth at least $10 billion. Furthermore, and also hearsay. What up, Overtask? How are you doing today? What up, Kevin? Get home from work safe. Yeah, it's not even a witness testimony. It's just they're just claiming uh Diablo Chew, they're just kind of citing witnesses to this case. So they could be used as witnesses to this case, but anything that you're seeing quoted but not that doesn't have any kind of disclosure backing it up is very sus. Furthermore, by failing to move to dismiss for failure to state a claim, defendants have effectively conceded Nexon's claims past the threshold. Oh, thank you for the popcorn. Um, so there's a TLDR pinned at the top. Phantom has been kind of updating the TLDR, and I've just been pinning it. Euler. But like the biggest takeaway so far is that I would say like Nexon has made like 2.5 valid points in the past 45 pages. Sorry, I'm gonna eat some popcorn. Um, Even if there was evidence that defendants' financiers were under a significant financial burden, which there is not, there's also not evidence that they aren't. Defendants claim that they need to translate thousands of pages of exhibits submitted in Korean proceedings costing hundreds of thousands of dollars, if not much more. It is grossly exaggerated. Some documents, such as parties' DMCA correspondence, were originally prepared in English. The lawyer's part was, but the Terrence and Mr. Choi's weren't. Other documents, such as extensive discussions of Korean copyright law, would be of no value to either this court or a jury. That's opinion. You can't state whether or not that would actually be of value to a jury or the court, because the jury or the court might want to know what the Korean laws and what their stances are on that. Translations of other documents can be limited to relevant portions. For example, the portions of Nexon's employment policies referencing confidentiality obligations may need to be translated, but defendants have shown no need to translate all employee policies. Also, Nexon is trying to have those contracts thrown, and they probably don't want them translated accurately because they're trying to have the accurate translations thrown. While none of the defendants' U.S. legal team may speak Korean, defendants clearly have bilingual people working for them that can spare them the expense of paying for certified translations or irrelevant material. False, because certified translators have to be in place when you're talking about any kind of certified documentation on the court. You can't just have some rando dude come in. Some biased Iron Mace employee can't legally act as a certified translator for legal documents and legal documentation. It's not how that works. Finally, delaying the commencement of discovery would only increase the likelihood that critical evidence will be unavailable once during discovery begins. Damn, popcorn's trying to kill me. Defendant began concealing evidence when Choi deleted his personal servers to prevent Nexon from conducting a forensic audit of how he used the data he stole. He was told to by the employment contract and his lawyer. He was told to do that. So the employment contract stated that he needed to delete it, and his lawyer advised him to. So he was in the right for doing that. So now saying that he destroyed evidence is kind of a not real argument. It's an opinion. It's an opinion not based on fact. Defendants continue to suppress evidence by refusing to produce source code in Korean litigations. They haven't refused. They've never been asked. While defendants publicly claim to be committed to transparency, they have taken every step in their power to avoid letting the full truth come to light when brought to court. That's all opinion. Defendants have hidden the evidence of their wrongdoing long enough Opinion: defendants have not set forth any good cause for more delay. Opinion: conclusion: the foregoing reasons the court should delay motion to stay. Oh, is that tea? Is this an Arnie Palmy? It's Arnie Palmy time, guys. Who wants an Arnie Palmy? Thank you. Yeah, and there's no witnesses being brought forward for any of these claims. I really hope Tana played. Yeah, right. If the judge played PT5, that'd be amazing. So then they certify that this is all true and not a lie. Now, is there another document attached to this? I don't think so. So this is it's basically sweet tea with lemonade. So the next steps here, right? Judge is sitting there sipping coffee from the dark and darker mug. I'm gonna eat my snack. My Mrs. Derp is amazing, by the way. She brought me popcorn and an Arnold Palmer. So what's next? We're pretty much waiting on the 21st to hear what the decision for this is. It's going to go one of two ways. It's going to be granted or dismissed, or granted or not granted. I guess dismissed. I wasn't able to get the coffee, unfortunately. I was broke AF when the coffee came out, and I was super mad. But yeah. So what's next is we wait till the 21st to see if this motion to stay discovery gets pushed through. I am, after today, I would say I'm about 60-40 that motion will go forward. I think that they have a good chance of getting the discovery stayed. I don't like a lot of the arguments that Nexon made. I think that the most valid argument is that even if discovery moves forward, regardless of cost, they could still use all that information in Korean court. Because that's a super valid argument. And it's like completely by the book. But most of their other arguments that they made were kind of BS and opinion based, and they didn't even quote all their sources. So it's kind of a shit show. Now, as far as their Sir reply, yeah, the TLDR basically sums it up. You know, they're trying to have basically all of Iron Mace's replies thrown out using the same sneaky tactics that they did, but there's not really any valid arguments there as to why that information should be stricken. It's other than like we don't like it. There's no like legal arguments based in reality and fact, and at least in my opinion, that say like anything but like we don't like that argument, so please throw it out. And that's not really a basis for having something thrown out. I'm trying to be as unbiased to like Nexon as possible, but obviously I do have bias towards Iron Mace. I love the game. SDF and Terrence are, and Grayson are all badasses, and they're all seem like really cool people. So this, if Nexon had made more solid arguments and bases, if Nexon did a better job of basing their information off of facts instead of opinions and like citing actual precedent with quotation and expanding upon their arguments in a more concise way, and not repeating themselves, I think that their arguments would hold more weight. But I think that they're not doing that because they're just trying to conflate issues and muddy the water and kind of obscure all the details, right? They're trying to put everything in this haze and this fog so that it's hard to pick out what's true and what's not. So that you have to spend they're using language that's going to force a judge to look over every single word 300 times in a 20-page document that could have only been 7, right? So it's it's very transparent what they're trying to do. They're trying to buy time and they're trying to stall so that IM is more likely to settle. Yeah, it's 20 pages of them repeating themselves. Exactly, Diablo. Yeah, if the mugs came out now or if they were like still available, I would have bought one. But yeah, at the time I just didn't have the money for it. I couldn't. I like was like, do I not pay for this and buy a mug? And then I was like, no, I need to need to cover my essentials. It happened at like a really bad time for me financially. I'm gonna push the mic away a little bit away from my face. Let me know if you guys can still hear me. I just don't want to like chew directly into the microphone because I'm gonna snack on this popcorn. Same here. That they have been doing a shit job. I mean, they have smart lawyers. They are doing a very, 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 very damn good job of doing their job. Right. Um. Just call. Uh. The big guy. The big guy is trying to bury them. Um. So Nexon's lawyers are doing a very good job of doing their job, which is to try to force a settlement out of which is trying to force a settlement out of Iron Mace. Are they doing a job of trying to win this case? In my opinion, no. But I don't think that's their job. Their entire purpose is to get Iron Mace to settle, to get them to sign an NDA, and to get them to move on and go back home to Korea with a huge bag of money and a non-disclosure, so that they could tell everybody that they won without any kind of repercussion from Iron Mace. Um, what up, Jaw Rule? We have a TLDR up at the top, and I'm kind of going over some stuff. But yeah, I really don't think that Iron Mace has too. I mean, it's too early to tell still, but I'm not like fearing for Iron Mace's case. I thought this was going to be a lot closer. I mean, I thought this was going to be a lot closer or even a lot more one sided in Nexon's favor than it has been so far. And Iron Mace's, like, I was fully not a doomer, but I was like, Iron Mace is kind of fucked here. Like, no matter what, just because of how much money Nexon has. And I still think that Nexon is still at a huge advantage in this case, just because of how deep their pockets are. But like the case has gone from me I have gone from me thinking that Nexon is just going to kind of steamroll Iron Mace and either settle or win, to just because they have so much money, to the only outcome I see now is a settlement for like either party. I don't think Nexon has a strong enough case to win. I don't think Iron Mace like realistically has enough money or a strong enough case just to like straight up win out of merit. um I think they have a good chance of getting it dismissed in the United States, but in Korea it's another story. I think it's more of a not as black and white situation, and I think that Nexon has overplayed their hand very heavily, and they're kind of showing their cards, right? Where they're basically making the argument of like, "Hey, give us a million, give us all the time that we want, but don't give them any time," right? Um, so fair as in a large amount of their replies are just kind of opinions and like double speak, and a larger they're trying to have a large amount of Iron Mace's replies thrown out and stricken from the record. Yeah, it's like basically half or more of their declarations are trying to have thrown out. I hope the crunching isn't too bad. I'm trying to like keep it as quiet as possible. I know eating on stream is super rude, but I've been streaming for like 3 hours. Need a snack. Oh, sweet. Um, yeah, thanks for the sub, Diablo. I appreciate it. Um, just call it crunch on the mic and call it ASMR, and then I'll put my feet up on the desk so that you guys can see my feet. All I need after that is like a hot tub. Go on Twitch. Popcorn. Yeah, I believe eggplant. I believe it should be the 26th, on or before the 26th. Unless some kind of like extraneous circumstances happen and the court needs to delay it, or the judge feels like they don't have enough information, then they can delay the dismissal. But most of the pretrial hearings are going to be done on or before the 26th. That's their like scheduled date. And that's according to the court administrator. I called the court administrator. If this didn't come out tonight, because I knew that there was a chance that it would come out around like 10 or like before 10, because they do final updates at 10 o'clock and then they take the servers offline to do maintenance. So 10 o'clock is basically the last chance for anything to happen on Pacer or um, Court Listener, because the Pacer servers actually get taken off of line for maintenance at 10 o'clock, at least to the best of my knowledge. Swimming pants changing stream. Um, we probably won't hear it until the 26th. It could be earlier. It really depends on what the judge sees and all this stuff. And then I highly doubt that Iron Mace is going to file a reply themselves. Um, I don't think they merit. I don't think that this reply merits it. Yeah, basically, we'll have more information about this on the 21st. The delay, the stay of the discovery. We'll hear more about that on the 21st. So yeah, the note on the motion calendar is the 21st for this to be decided upon. So we'll know. So literally tomorrow, my time, because it's 12:47 in the morning. Tomorrow my time is 21st of July, 26th of July, and then for the Korean injunction is should be somewhere around like the 21st of August for the Korean injunction. Oh shit, Phantom. That is early in the morning. Also, what up, Keegan and Mr. Julie 123? How are you guys doing? 90. So do you think they'll release EA before the Korean case is settled? Possibly. Um, Spooky Skeleton. Um, and so I think that EA, if we get a dismissal or a favorable injunction on the 26th, um, there's like a 2 month window where Nexon, a 1 to 2 month window where Nexon couldn't send any DMCA's to Iron Mace, and that would be like the perfect time for Iron Mace to put out early access, because it's A, legal in the United States, and B, Nexon can't shut it down. They couldn't do shit about it. And that's also when they should find out about the Korean injunction would be in sometime in August, right? Like mid to end of August at the latest should be around when they hear about the injunction. in Korea. So it bleeds over into it could be if everything works out perfectly, it would be dismissal or positive injunction in the United States on the 26th. And then a positive injunction in Korea sometime in the middle of August. Because what that does is it gives Iron Mace at least 30 days for the injunction in Korea to happen. And if that both of those things happen, then Nexon can't do shit at all until they win. Would have to have an appeal granted and win the appeal to reverse the injunctions or the dismissal. So yeah, if it happens like that, there's not a damn thing Nexon can do about it. Like EA comes out and stays out. Um, yeah, and if it passes injunction, EA it would probably go back up on Steam. Like I'm almost certain it would go up on Steam. Um, I think they might. I think there's a good chance that they would. If there's a U.S. dismissal, I think there's a good chance that they release EA. Nexon would have like a month to where they couldn't send any DMCA's, and then after that they would have to appeal. They'd have to appeal the decision, whatever it was, in the United States, and then they could start filing DMCA's again once the appeal is going. But they'd have to go through the Hague. But the big thing is that if the injunctions in Korea and the United States go through and they stick, or the case in the U.S. goes through and it sticks, then Nexon will probably drop their settlement in like half, right? Because the whole point of Nexon's settlement and the whole reason why they're trying to delay for as long as possible right now is to prevent Iron Mace from earning money. If Iron Mace gets an infusion of like I don't know $60 million, um, then it's almost game over for Nexon. Iron Mace can fight it forever. We're still hanging out for the 26th. The boy. I can't believe there's 85 people here. um, but yeah, I'm gonna probably play some TFT and chill and answer some questions because I think we've read through all the documents. Play a game of TFT or two, answer questions, and hang out if you guys are down. Yeah, of course, the boy. That's it's fun for me. I like reading. I'm gonna read this stuff anyway, right? And now this is kind of helping me do a lot of stuff. It's like helping me. I've had a huge fear of public speaking my entire life. I've been extremely camera shy for my entire life. Um, I'm like for the most part an introvert, so this is kind of helping me get over a lot of that stuff. And um, yeah, it's just really fun. I mean, it's fun. I get to hang out with all of you guys, right? Like I'm here talking to like 80 people, just chilling and talking about a game that I love, um, and learning about the court case and like growing, right? Learning stuff. Um, I'm not sure, Redisi. I think that our Nexon is going to try to pull as many delays out of their ass as possible. Because Nexon's being a little bitch. Sorry, I had to. Somebody requested it. I will. Oh shit! I have ads on. I don't think I'm supposed to be cussing that much. Uh, Okay. There we go. So what should I do? Normal for TFT, normal ranked. I don't even know what Soul Brawl is. Let's figure that out. Train up. Health is replaced with soul power. During training, you cannot die. Focus on building your soul power with Soul Fighter, Gwen, and Set's help. Champions given the soul crown item. Okay, this sounds confusing, and I don't want to do it. Hyper roll it is. Well, I'm glad you're talking here, Phantom. And you're always more than welcome to just hit me up on Discord. If there's one thing I don't want to ever happen to my stream and like the community that's building up around it, is for me to not interact with the community directly and to not respond and hang out and play games with the people that are part of my community. Those streamers that just get like too big to even like interact with the streamer, like the people that are part of the community that they've built, I just don't get it. Like, if it's that big, then something needs to, like, you need to find better ways to manage the community itself, right? Because at some point it does get too big for you to like hang out with everybody in like a smaller setting, right? But yeah, I play TFT all the time. I do hyper roll a lot. Hyper roll, normals, ranked every now and then. I'm not that great, but it's fun. And it's something I could play while I just like shoot the shit on here, right? Hold on. How's the game audio? Is it good? Yeah, and it's pretty chill. Oh. Yeah, I just want to be like. Yeah, we're just chilling. I mean, that's the whole point, right? Like, I don't want. I think I might go Rogue. Was it Rogue Slayer? Challenger, nope. Yeah, Greg, it's a slow chat. I get to interact with you guys. Like when I see those chats on like Asmongold or like, you know, people with like 100,000 followers and shit, or like millions of followers, and it's just like blasting by and you can't really see anything. I don't understand how people keep up with that. You know, I don't get it. Like I'm like part of my favorite part of streaming is like sitting here talking to you guys. Oh, what? Yeah, this is chill. I love this community. And like it seems like the people that watch my videos are also super chill, which is awesome. I haven't had a lot of trolls. There's been some people with like some complaints and stuff, but like, and like the rare trollish behavior, but it's not really anything significant or crazy. Not this.
Where there is evil, I shall go.
I don't really care about this Maokai.
Where there is evil, I shall go.
Yeah, I completely agree with you, Phantom. The people who are going to sit here and watch me talk about court documentation for 2 hours probably aren't the same type of people that are going to come in here and start raging. But yeah, that's why I like it. You know, it's chill. And you guys are super supportive and super helpful, and like you guys have all been super kind and generous. Like it's been incredible. It's been amazing. I don't know who I want to start putting items on yet. Nice. Hermic 2, nice. Hey, Phantom. Just hanging out, chatting, and talking about the case, and you know, helping pin, like making pin comments and TLDRs. Like that's all I could ever ask, right? I never really expect any kind of financial anything from anybody. I'm just super glad that people are watching the stream and hanging out. I mean, there's 57 people watching me play TFT right now and talking about Dark and Darker. I don't care about a lesser champion duplicator right now.
I will snuff yours out.
I never really got into short form horror. I do love some a good horror flick though. I'm getting wrecked.
What I have done.
Yeah, I don't watch a lot of Twitch. I do a lot more YouTube, and I've subbed to a few people. But I have to like really like their content. Yeah, I can't wait to see how the live development works, because all we've really seen is like behind closed door, pretty safe development. We haven't really been able to see a lot of like behind the like live gameplay and like live updates. Whenever you start up a champion, get a free shop refresh? No. Random emblem? Damn it. Yeah, Bard was amazing. It has a really versatile kit. Not enough people were using it with crossbow and hand crossbow. Rapier mastery with a hand crossbow and then a crossbow as a secondary was OP.
Dawn is the future.
Man. No good.
Dawn's future is about to get brighter.
The Isles will be cleansed.
What is this game called? Oh, it's Team Fight Tactics. It's like part of League of Legends.
This land was made for me.
Pretty good. Oh, damn it, that's why. Somebody else went Noxus. There we go.
Dawn is the future.
There we go.
Where there is evil, I shall go.
Hey, Wounded Healer, have fun. Have a good night. Thanks for watching. Thanks for the support. Yeah, hopefully we get good news on the 26th. Roguing around with my little epic hand crossbow on ruins. Yeah, it's great.
Blood for Noxus!
Huh.
The Isles will be cleansed.
Oh yeah. Just freaking stack a whole bunch of debuffs on the all the poisons and stuff. I'm so dead. Die. Yeah, like hand crossbows were very rare. So like you could actually sell gray hand crossbows pretty easily. Rock and popcorn all over my office. Oops.
Dawn is the future.
Damn it.
I am Nexon. Your gods fear me.
Oh shit, where did I get a fucking Aatrox? Oops.
Welcome to Zon.
Love for Noxus.
Yeah, does he do AP? There we go. There's my team, basically.
Dawn is the future.
I have done cannot be undone.
Noxus will rise.
Right to glory.
Did I play the two? I haven't yet. I gotta try it. I gotta download that thing, Jordy. I gotta try the or download the. Yeah, I'm done. Oh no! That's rad. That's so rad. Yeah, I haven't played 2v2v2 yet. That was chill. 50 is fun. 5th place, not great. Yeah, I did a lot of hand crossbow rogue, like hand crossbow rapier. I did rapier hand crossbow bard as well. It's just a good combo, good pair. The only people that could really do anything against you is like single stiletto or single Chris rogues because they're just slightly faster than you, and if they get inside the range of the rapier, like they just attack so fast. You're done. But yeah, I played with a lot of groups. I can't wait to play with some of you guys. It's gonna be so fun. I think we're gonna have a great time. I like playing with new people and just hanging out. Hey, that's cool. I just went to YouTube and my live stream was like, it popped up as recommended. Rad. I'm getting recommended on the homepage. That's freaking cool. Yeah, I think I'm gonna play one more game of TFT, and then I'll probably it's already 1:15, so I'll probably head out after that. But yeah, ask me any questions you guys want. I'm hanging out, just playing TFT. We went over the court case, all the new documents and stuff. Why is it not showing up? What happened to my stream? Why is all my stuff blacked out? Full Shurima yet? I haven't. Is full Shurima good? Maybe I'll try it. If Kraken wants me to go full Shurima, I'll go full Shurima. Hey, if it's fun, that's all that matters, right? I'm just playing hyper roll. It's not like I'm playing competitive. I'll try a full Shurima team. Full strategist is actually rad. Full void's pretty cool too. I don't know what Shurima has. Yeah, I'll take a free Texertion's Crown.
Keep your enemies close, and me.
So what do I pair with the Shurima? Like strategist or something? Invoker maybe? Or maybe I do Noxus? Noxus or Failure? Probably do Noxus.
But Noxus will remain.
I'll take care of everything.
But yeah, what are you guys up to? How are you guys up to? What are you guys doing this fine evening? Middle of the week evening.
Keep your enemies close, and me closer.
Do I already have a gold cast? Almost? Oh no, it's almost, yeah. Never mind. I think I might go champion duplicator on this time.
I'll take care of everything.
Yeah, I'll check him right now. The,
finest.
the awesome. Okay, hold on. Or my cup of Arnie Palmy. Nice, dude.
This world is frayed and in need of mending.
Yeah, why does that happen? Does anybody know why that happens? Borderless instead of full screen?
I will tear the world asunder.
This.
The world may fall to darkness, but Noxus will remain.
What does Shrima do again? Every 4 seconds, Shrimas heal 5% maximum health after 8 seconds. Shrima's. Oh, select a Shrima? The strongest Shrima in a sense?
Keep your enemies close, and me closer. This world is frayed and in need of mending. This world is frayed and in need of mending.
Do Shrimas have a Slayer? Yeah, these rounds are pretty quick. It's fine. No, it's chill. I'd rather talk to you guys. I mean, I don't really care. This is just hyper roll. There's nothing important going on. I'd rather talk to you guys and hang out than worry about what's going on in here.
Live on without you.
I'll take that. I'll probably toss you and you. You too.
Vengeance calling.
Dota was so fun. Dota was so fun. Like the original Dota. I haven't played Dota 2 in forever. But like the original Dota was... I love that game. So many good memories.
Knock knock. Vengeance calling.
I will tear the world asunder.
So I know I probably want Swain.
A Noxian always rises to the top.
What do I want to... she's probably going to be golden, so I guess I'll take that.
This land was made for me. Me alone.
That works.
The world may fall to darkness, but Noxus
3 hours in Dota 2 I quit a few years back. That was the right choice. Yeah, Dota was, I mean, Dota's better than League, for sure. Juggernaut? They sure do.
Noxus will.
And then they have a Bastion. Does Noxus have a Bastion? I still want to play Shiv 2.
Shurima is where all paths converge.
Oh, here we go. Got it.
Consider yourself absolved.
See, I shouldn't be spending so much time playing games. I mean, I should be realistically using this break from Dark and Darker to um to work on my game.
Shurima is not of this time.
The world may fall to darkness, but Noxus
Yeah, I'm pretty lucky that I've played through at least most of the games that I've purchased. What up, Wolfram? You just missed me getting stomped at TFT. But yeah, guys, thanks for hanging out. I think I've been streaming for like 4 hours now. 3 hours, 3.5 hours. Yeah, that's kind of why I've just been playing small games, like indie games, and then like the same stuff I've played already, like LOL and a little bit of Modern Warfare 2 every now and then. I was playing Cycle until they decided to cancel it, and now I'm just not interested in playing it because it's going to be canceled. You know, it's like a white, but it doesn't come back. Yeah, I just want to play Dad. I should be working on my game more than I am, to be perfectly honest. But between the court cases and making content, it's just kind of taking up a lot of my time. Luckily, there's some people that might be coming on to like help out, which is pretty cool. So hopefully I could get some help with that. I want to build out a team for the game, get more devs working on it. Yeah, come back whenever, Diablo. Thanks for joining. I really appreciate it. Um, I'm super glad that you found me. I don't know how you found me, but I'm glad you did. Um, come back whenever. I'm super proud of this community that's building, and I'm super glad to be finding a lot of people that are just all like really just super chill. You guys are all awesome. But yeah, I think I'm gonna call it a night because it's 1:30 in the morning. I'm gonna finish this popcorn and this Arnie Palmy and probably hang out with the lady. But yeah, thanks guys. I really appreciate it. I hope you guys enjoyed your night. I hope you guys all got the information you were looking for. I'll probably make a video about this tomorrow that sums up a lot of this stuff that we read. But yeah, thanks everybody. I hope you guys have a wonderful evening, and I can't do this without you guys. So yeah, come back whenever. I'll be streaming anytime there's a document drop, or if I'm just hanging out at home chilling, I'll stream. I also do want to do like a dev stream here for my game here pretty soon. I'm trying to keep that a little bit separate, because I plan on making my own like devlog channel for all that stuff because it's like not really related to this channel in any way. Um, but some people have been asking me to like kind of show what my game's doing and what I have so far. So I want to take people into the back end of it, into the like go into Unreal 5 and show everybody what I'm doing. Yeah, why wasn't my face on the stream? What up, guys? I don't know why my face wasn't here. But yeah, I'm gonna be streaming. I mean, basically whenever documents drop, but and then streaming more often. I do want to do a dev stream. I do plan on making like 1,000 subs video. I know that I passed like 12. I'm like at like 1,200 now, but I do want to do like a 1,000 subs video too. So I'll make a video about what happened or all this documentation tonight. So I'll make that tomorrow, or technically later today. Um, and then I have 1,000 subs video coming up, and then I want to do at some point I want to do like a dev stream where I take you guys into my game and just show you around. I'm not like embarrassed. I'm a solo dev. This is my first real project. You know, I have some other projects that I've been working on and stuff too, but this is my first like big time real project. That actually has a chance of getting some funding. So, I just kind of want to show everybody what I'm working on. But yeah, thanks everybody for hanging out. Thanks for stopping by. I hope you guys like the stream. Peace.